पैसा कटना शुरू हुआ, तब पैसा निकलना शुरू हुआ।
Harmeet ma'am, shall we start?
Yes, Anjali. Yes, let's start.
Good afternoon, everyone. I welcome you all to the second session of Workshop Series 5. Today we have with us Ms. Harmeet Kaur as faculty for taking session on the topic distribution of assets and waterfall mechanism. Ms. Harmeet Kaur is insolvency practitioner, lawyer, and practicing company secretary. She is presently a designated partner with RRR Insolvency Service Experts LLP. Academically, in addition to being an IP, she is commerce graduate from SRCC LLB and has done postgraduate diploma in business administration and computer application. She is having more than 15 years of industry experience in secretarial and legal areas. She is also a certified trainer and has been empaneled as faculty with ICSI. She is committed towards the empowerment of women and to propagate the idea of gender equality. Ma'am, you may now start the session, please.
Thank you, Anjali, for the wonderful words. And thanks to the Institute for giving me this opportunity to interact with the fellow IPs. And I would request all the IPs to keep interacting wherever they have any suggestion, any of their own experiences, they can share with us, with all of us. But till such point that is relating to the context, kindly refrain from, going beyond the subject today, because IBC is so close to our hearts that once we start speaking about it, about any subject, we lead to, any lens. And all of us are having immense knowledge, having practical knowledge also. So it will be useful for all of us to, for the others to listen to your experiences as well. So with this, I start the presentation. Shall I share the screen? Anjali?
Yes, ma'am.
Yeah. Okay. Keep interacting, otherwise I'll also sleep while speaking. Okay. So the subject today is distribution of proceeds and waterfall mechanism. And I'm sure all of us, I mean, all means, even if we are, whosoever is not an IP is aware about Section 53, because this is, we love it or we hate it. Section 53 is there in our lives like anything. All bankers are aware about it, all advocates are aware about it, and even the articles, even the junior most staff in an IP is aware what 53 means. So let's discuss and let's see what we can find out in this subject today in 3 hours, So we will go through the history of distribution proceeds and the priorities set out by the legislature in India, why the history is important for understanding any present situation, whether it is politics, religion, or any subject. We must know the history regarding that so that we are aware that in under which circumstances, which steps were taken by the legislature, how the people reacted, and what was the will of the people. So here, winding up was covered under, we are aware about these about the other acts and laws. I am not covering them. I'm sticking myself only to the priorities under the distribution of proceeds chapter. So the winding up of the company was covered under 1956 as well as 2013 Act. After the amendments made by because of IBC, Section 255 of IBC led to certain amendments under Companies Act 2013 also, and it was amended as it was specified under Schedule 11th of IBC. Schedule 11 is quite vast. I have only taken a few concepts to just bring you on the path where we need to follow the presentation today. So it starts with saying that the company liquidator would mean so and so. And thereafter, it has added the winding up definition, which would mean winding up under this act or liquidation under IBC as applicable. So winding up was earlier available under 4 parts, was earlier described under 4 parts, and there were certain sections which have all been omitted now. The voluntary winding up as a concept is not there now. Similarly, other winding up modes have also been which were there on the ground of inability to pay the debts. Section 253 to 269 have also been removed from the Companies Act, and Companies Act now leads you to the IBC only, because winding up would mean winding up under Companies Act or under IBC. Companies Act only deals with the situation where the tribunal can wind up a company, right? So that is covered under Section 271. And Section 271 started when MCA notified the provisions of Chapter 20 of the Companies Act with small changes to this section by removing the ground of winding up on the basis of inability to pay debts, and to include only the circumstances in which the company may be wound up by the tribunal. So those circumstances I have listed here, if we can go through them quickly. If the company has by special resolution resolved, as such, if the company has acted against the interests of sovereignty or integrity of India, the security of state, etc., etc. If on an application made by ROC or any other person authorized by central government by notification under this act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, or the company was formed for fraudulent and unlawful purposes, or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, it is proper that the company be wound up. Under any of these circumstances, in addition to that, they find it proper that the company be wound up. Another circumstance is if the company has made a default in filing the returns, etc., with ROC for a continuous period of 5 years. If the tribunal is of the opinion that it is just and equitable that the company should be wound up. Under the 1956 Act, the priorities of payment were there under Section 530. So most important aspect of this section, I would just want you to see the 1A. A says all revenues, taxes, cesses, and rates, etc., from the company to the central or state government or to a local authority at the relevant date as defined under section so-and-so. So important here is that prior to 1985, this section remained as it is for so many years, and only the government dues were given the topmost priority. And thereafter, there was a change in thinking. And under 2013 Act, the workmen dues were given the topmost priority under any winding up. The preferential payments, they call it. We don't call any payments as preferential payments because under IBC, the preferential payments has a separate, different meaning altogether. Under Companies Act, now, not now, prior to IBC, the payments were made as in this format, the workmen dues and debts due to secured creditors were given the topmost priority. Thereafter, the government dues, thereafter the wages, etc. Or salaries due to the employees other than workmen, thereafter holiday remuneration, and thereafter the other dues to the employees, basically. BLRC was formed with an objective to implement a code so that there is a low time in resolution, there is a low loss in recovery, and higher levels of debt financing across a wide variety of debt instruments. So this was the objective of forming the committee, and these were the objectives they were trying to achieve by implementing the new IBC. So part 1 of the BLRC report deals with these objectives, and part 2 is having the model IBC which they proposed. So the performance of the new code in implementation will be based on the measures of these outcomes only. Here in the original draft, the clause 53 of the BLRC report stated that the insolvency resolution process costs and the liquidation costs shall be paid on top priority. Thereafter, following debts shall rank shall rank equally between and among the debts owed to a secured creditor. In the event such secured creditor has relinquished security in the manner set out in section 52, and workmen's dues for a period of 12 months preceding the liquidation commencement date. So that was the initial draft. Thereafter, third point is the wages and unpaid dues towards the employees other than workmen for a period of 12 months, and the other points we are aware. So after this draft was placed, the committee itself observed that in the event of a company becoming insolvent, the workmen are getting adversely affected, and therefore the priority has to be given to their outstanding dues. So to protect the interest of those workmen, the committee was of the view that their dues for a period of 12 months as provided in the waterfall mechanism under section 53 and 178 may be considered to be as 24 months preceding the liquidation commencement date. So thereafter, the manner in which the priority was proposed is the way as we see the section 53 today. So section 53 as in the IBC today is having these exact words. So I would request all of you to just go through these, the exact text of the section, because this is the heart of the insolvency law, and our entire presentation today is based on this section itself. So it starts with a non-obstante clause stating that notwithstanding anything to the contrary contained in any law enacted by the parliament or any state legislature for the time being in force, this itself gives immense power to the section 53. Thereafter, it says the proceeds from the sale of liquidation assets shall be distributed in the following order of priority and within such period and in such manner as may be specified. Namely, these insolvency resolution process cost and the liquidation costs to be paid in full. The following debts which shall rank equally between and among the following, that is the workmen's dues for a period of 24 months preceding the liquidation commencement date, and the debts owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out under section 52. Next level is the wages and any unpaid dues owed to the employees other than workmen for a period of 12 months preceding the liquidation commencement date. Financial debts owed to unsecured creditors. Thereafter comes the dues which shall rank equally between and among the following: any amount due to the central government, state government, including the amount to be received on account of Consolidated Fund of India and the Consolidated Fund of State, if any, in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date. And the other one is debts owed to a secured creditor for any amount unpaid following the enforcement of security interest. Thereafter, any remaining dues and debts, all debts when paid, thereafter the shareholders will come. First the preference shareholders and thereafter the equity shareholders or the partners of LLP or the partnership, as the case may be. Any contractual arrangements between the recipients under subsection 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. Any contractual arrangements would mean maybe there are certain arrangements between OCs or the FCs having certain rights which give them higher rights, having superior rights over the other party, and they are coming in your way of calculation of equal proportionate rank debts, then that has to be disregarded. The fees payable to the liquidator shall be deducted proportionately from the proceeds payable to each class of recipients under subsection 1, and the proceeds to the relevant recipient shall be distributed after such deduction only. For the purpose of this section, it is clarified that at each stage of distribution of proceeds in respect of a class of recipients that rank equally, each of the debts will either be paid in full or will be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. And the term workman's due shall have the same meaning as assigned to it under section 326 of Companies Act. So this is a chain. When you go and find out the meaning of workman, it will lead to finding out a treasure, like a game. You start from here, then section 326, it will take you to the Industrial Disputes Act and so on and so forth. So let us see what section 326 has to say, because this is also affecting IBC in certain manners. And recently in Mosavia matter, we have seen that section 326 and 327 have been deliberated upon in detail. So this section says that in the winding up of a company under this act, the following debts shall be paid in priority to all other debts. So this is how our Companies Act has given a waterfall in case of a winding up. Workman's dues, and where a secured creditor has realized a secured asset, so much of the debts due to such secured creditor as could not be realized by him, or the amount of workman's portion in his security, whichever is less, pari passu with the workman's dues, provided that in case of the winding up of a company, the sums referred to in subclauses 1 and 2 of clause B of the explanation, which are payable for a period of 2 years preceding the winding up order, or such other period as may be prescribed, shall be paid in priority to all other debts, including debts to the secured creditors, within a period of 30 days of sale of assets, and shall be subject to such charge over the security of secured creditors as may be prescribed. The debts payable under proviso to subsection 1 shall be paid in full before any payment is made to secured creditors, and thereafter debts payable under that subsection shall be paid in full unless the assets are insufficient to meet them, in which case they shall abate in equal proportions. So here the workmen are better off. Workmen in relation to a company means the employees of the company, being workmen within the meaning of clause S of section 2 of Industrial Disputes Act. Workmen's dues in relation to a company means aggregate of the following sums due from the company to its workmen. This explanation is given under section 326, and this is for the purpose of this section as well as for section 327. And the workmen and the workmen's dues would derive their meaning from this section for the purposes of IBC as well. So workmen's dues are defined as to include all wages or salary, including wages payable for the time or piecework and salary earned wholly or in part by way of commission of any workman in respect of services rendered to the company, and any compensation payable to any workman under any of the provisions of the Industrial Disputes Act. Second, all accrued holiday remuneration becoming payable to any workman, or in case of his death to any other person in his right or the termination of his employment, unless the company is being wound up voluntarily, merely for the purposes of reconstruction or amalgamation with another company, or unless the company has, at the commencement of winding up, under such a contract with insurers as is mentioned in section 14 of Workmen's Compensation Act, rights capable of being transferred to and vested in workmen, all amount due in respect of any compensation or liability for compensation under the said act, in respect of the death or disablement of any workman of the company. All sums due to any workman from the Provident Fund, Pension Fund, gratuity, or any other fund for the welfare of workmen maintained by the company. Workmen's portion what does that mean? In relation to security of any secured creditor of a company would mean the amount which bears to the value of the security, the same proportion as the amount of workmen's dues bear to the aggregate of amount of workmen's dues and the amount of debts due to the secured creditors. Now, what is section 2 subsections S, which defines a workman? Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purposes of any proceeding under this act in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include those people who are subject to Air Force Act, Army Act, or Navy Act, or those who are employed in police service, or as any officer or employee of the prison, or who is employed mainly in a managerial position, or who is employed mainly in a supervisory capacity and who is drawing wages exceeding 10,000 rupees per month, or exercises either by the nature of duties attached to the office or by reason of powers vested in him, functions mainly of a managerial nature. So that person would be included in the definition of employee. Now, what does section 327 says? In a winding up, subject to the provisions of section 326, there shall be paid in priority to all other debts, all revenue, taxes, cesses, and rates due from the company to central government, state government, local authority, etc. So you can see a departure from 1956 Act. Like 326 talked only about the workmen and the secured creditors. 327 is talking about subject to the provisions of 326. That means after paying to those two categories, if at all something is left over to be distributed to the stakeholders, then section 327 distributions shall start. So these are all the section 327 rankings. Debts shall rank equally among themselves and be paid in full unless the assets are insufficient to meet, in which case they shall be abated in equal proportions, etc. So only the hierarchies are different, other manners are similar. But a very important point, a very important subsection which has been inserted in this section, which I would want your attention to be drawn to, that is subsection 7, and that says section 326 and 327 shall not be applicable in the event of liquidation under the IBC. For the purposes of this section, accrued holiday remuneration would mean so and so. The expression employee would not include a workman. Relevant date would mean so and so. So under Companies Act, this explanation would work. Now it is important to see a recent judgment under Mozapia versus Karamchari Union versus Union of India, wherein section 326 and 327, especially, sorry, not the entire sections. So section 327 was alleged to be arbitrary and violative of Article 21 of the Constitution of India. The petitioner sought for an appropriate direction as to leave the statutory claims of workmen's dues out of the purview of waterfall mechanism under 53. As per section 327 subsection 7, 326 and 327 of the Act of the Companies Act shall not be applicable in the event of liquidation under the IBC. Therefore, 326 and 327 provide, we are aware that they provide for preferential payments in a winding up under the Companies Act. However, in view of introduction of the new regime under IBC, in case of liquidation under IBC, the distribution has to be made as per section 53 of Insolvency Act Code. The Honorable Supreme Court held that the object and purpose of amending the Companies Act and to exclude section 326 and 327 in the event of liquidation under the IBC seems to be that there may not be two different provisions with respect to winding up and or liquidation of a company. Therefore, in view of the enactment of a specific code which has been made for this purpose, it is necessitated to exclude the applicability of the other preferential payments which are there under 326 and 327, which cannot be said to be arbitrary as contended on behalf of the petitioner. Therefore, merely because under the earlier regime, And in case of winding up of a company under the Act 1956 or 2013 prior to the amendment, the dues of workmen may have pari passu with that of secured creditor. The petitioner cannot claim the same benefit in case of winding up or liquidation under the IBC. The parties shall be governed by the provisions of IBC in case of liquidation of a company under Insolvency and Bankruptcy Code. Section 53 of the code, which begins with a non-obstante clause and states that notwithstanding anything to the contrary contained in any law enacted by Parliament or any state legislature for the time being in force, the proceeds from the sale of liquidation assets shall be distributed in the order of priority, which is stipulated and within such period and such manner as may be specified. The consequence of subsection 1 to the section 53 of the code is that it will override the rights of parties, including the secured creditors, when the said provision applies. Therefore, section 53 is a complete and comprehensive code which ensures collection of assets and then provides the manner in which the creditors are to be paid. Even the rights of secured creditors falling under section 53 of the code to enforce, realize, settle, compromise, or deal with the secured assets as compared to the security interest are diluted and compromised. Does anyone has a say on this last line? The rights of the secured creditor falling under section 53 of the code to enforce, realize, settle, compromise, or deal with the secured assets in the manner as they might have, as applicable to the security interest, are diluted and compromised. How and why this is said by the Supreme Court? The rights of the secured creditor to deal with the assets secured for their respective loans is diluted and compromised because of section 53. Simple, really simple, what I'm asking.
Means it ranks pari passu with the secured creditors.
Yeah.
So in case the secured creditors do not relinquish the right on his security, it means that at the time of sale, his right would be rank unequal with the employees.
Yes, with the workmen.
So this is the meaning, I suppose.
Yes, to an extent, yes.
And then priority of the insolvency expenses over that of the creditors.
Sorry, I didn't get you.
The priority of the expenses on insolvency
Yes.
over that of the
Yes.
secretary.
Yes. So that is how they are already falling on the second place. And their right to sell the asset directly and get their dues is getting compromised. Does anyone has a view on we recently let's reach to that slide. Let's discuss the matter, and then I'll take your views on a matter where I have a different view than what has been decided in that matter by the Honorable NCLAT. But definitely I would like to hear your views as well. So getting back to what happened in Waterfall, let's see what else the Honorable Supreme Court had held. They said clause A to subsection 1 of 53 deals with the CRP costs and liquidation costs which are to be paid in full. No grievance can be raised in such subject. B of subsection 1 states that the debts due in the form of workmen dues for a period of 24 months preceding the liquidation commencement date, and the debts owed to the secured creditor in the event such secured creditor has relinquished security in the manner set out under 52 of the code shall rank equally. Explanation to section 53 of the code states that the workmen dues shall have the same meaning as assigned to it under section 326. In other words, the explanation has been incorporated and applies to the waterfall mechanism as prescribed in clause B to subsection 1 of 53. So that explanation relates to 1B. Understood. What is significant here is that clause B of subsection 1 of section 53, the workman's dues are for a period of 24 months preceding the liquidation commencement date. The liquidation commencement date, as defined in terms of subsection 17 of section 5 of the code, is much earlier in point of time and need not coincide with the date of winding up. So this is in the interest of workmen. Makes sense. Clause I of explanation of 53 of the code states that where the distribution of proceeds in respect of class of recipients who rank equally, each of the debts would be paid either in full or would be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. So as the clause is very just and fair. It is to be noted that the wages and unpaid dues owed to the employees other than the workmen will all fall in clause C, which is below clause B. They are to be paid wages and unpaid dues only for a period of 12 months preceding the liquidation commencement date, and that too only if surplus funds are available after making payments in terms of clause A and B of subsection 1. Clause D of subsection 1 relates to the financial debts owed to unsecured creditors. The amounts due to central government, state government, etc., and the debts owed to a secured creditor for any amount that still remains unpaid following the enforcement of their respective security interests have been clubbed together in clause E and have to be ranked equally between and among both of them. The remaining debts and dues, all of them and any of them, shall fall under clause F of subsection 1. Preference shareholders fall under clause G, and equity shareholders fall under clause H. Subsection 2 of the code states that this is all has been written by under the order. If you must have gone through the order. So I have just copied from the text from the order itself, the judgment itself. So subsection 2 of section 53 of the code states that the contractual arrangements between the recipients under subsection 1 with equal ranking, if disrupting the order of priority, shall have to be disregarded by the liquidator. Now they come to a conclusion that waterfall mechanism is based on a structural mathematical formula, and the hierarchy is created in terms of payment of debts in order of priority with several qualifications. Striking down any one of the provisions or rearranging the hierarchy in the waterfall mechanism may lead to several trips and disrupt the working of the equilibrium as a whole and status, resulting in instability. Every change in the waterfall mechanism is bound to lead to cascading effects on the balance of rights and interests of the secured creditors, operational creditors, and even the central and state governments. Depending upon the facts, in some cases, the waterfall mechanism in the code may be more beneficial than the hierarchy provided under section 326 of the Companies Act, and vice versa. Therefore, we hesitate and do not accept the arguments of the petitioners. In waterfall mechanism, after the costs of IRP and liquidation, secured creditors share the highest priority along with a defined period of dues of the workmen. Here I give a pause again. I wish to listen to the views of my fellow friends on whether this 24 months for the workmen and 12 months for the employees is justified in your view. Very personal view, just asking for my curiosity.
No,
Why, sir?
it is because they are the people who had been associated with the company for so long, and they have put on their hard labor and everything, all the emotions, you may say, everything. So they should be rewarded accordingly. Not there shouldn't be in a fixed term as such. Wherein if you see that other people are the cost involved in that running a CIRP, it's much higher than what you in the capacity of workmen or
you carry the same emotions as I used to carry up to a certain a few days ago. I realized another perspective in this regard, and I wish to share that. Anyone else having the same?
But at the same time, if something has been cooked up in the balance sheet and by way of showing an extra employee, those kind of situations, that might
that may not have much of a monetary impact, Yeah. Anyone else is having same emotion regarding that 24-month period? Let me come straight to what I have just realized a few days ago, that consider a situation where liquidation commencement date has been so and so, and prior to that date, for up to 2 years, the workmen have not been paid. Can you think of a situation where an employee for 12 months and a workman for 24 months, they keep getting associated with the same company or a factory for that matter, or whatever way the organization has employed them, they keep their association alive with that organization without getting paid for almost 2 years? On what premise are they carrying on? Have they not found any other way to, realize their previous dues? Or 3 years, 4 years? I think realistically, it does not normally happen. And 24 months is why it is justified, because till such time workers of the factories, etc., go to the PF or other such offices, the labor offices, they take their whatever action is available for them. And employees, they do have other opportunities and they try and switch as soon as they can. And 12 months is actually a long time. You consider it prudently from your own perspective. Would you continue with an organization which stops paying you and does not pay you for a continuous period of 12 months? I don't think an employee who is in a managerial capability or a supervisory capacity would continue for such a long time.
Yes, you are right at this point in time, just because white collar job, like, they come to know and they just jump out of the ship before the ship is done.
So that is why supervisory nature people have been kept at next level. And the second point, we are dealing with the workmen, and for them, a liberal 24 months period has been given. So now, the more I read the code, the more I read the judgments, etc., although we do get some, the judiciary trend is such that we do get conflicting and contradictory judgments also. But when I apply my mind on how and why, from the history, naturally, the history of the BLRC report, etc., the more you read that, the more you come to know the logic behind writing each and every word under the code. And the regulations are also drafted after so much, effort. And I would request all of you to just participate in the review of the regulations that has been organized by ICSI IIP. I think I would request Anjali to just inform the dates in the break time, or just write on the chat box. So it is a wonderful opportunity to give your comments wherever you feel that some correction or some prudent suggestion might be of use for the entire community of this insolvency. So you must participate in those discussions with your points, having your points ready. So let's go back to where we were on the Moser-Beer judgment. In the waterfall mechanism, after the costs of the CRP, secured creditors share the highest priority, the unpaid dues of workmen are adequately and significantly protected in line with the objectives sought to be achieved by the code. And in terms of the waterfall mechanism, achieved by the code by way of the waterfall mechanism, in either case of relinquishment or non-relinquishment of security by the secured creditor, the interests of workmen are protected. In fact, secured creditors are taking significant haircut and workmen are being compensated on an equitable basis in just and proper manner. The code balances the rights of the secured creditors, who are financial institutions in which the general public had invested money, and also ensures that the economic activity and revival of a viable company is not hindered because it has suffered or fallen into a financial crisis. Financial crisis, inability to pay the debt, does not necessarily mean that the business is not viable. That we have understood after 6-7 years of this code and understanding the feasibility and viability of the businesses, which can be revived with infusion of a little money, or maybe with the change of management. So further, Supreme Court has held that the code to both the economy and exchequer at the same time through efficiency enhancement and consequent greater value capture. In economic matters, a wider latitude is given to the lawmaker, and court allows for experimentation in such legislations based on practical experiences and other problems seen by the lawmakers. In a challenge to such legislation, the court does not adopt a doctrinaire approach. That means there is no fixed formula. Some sacrifices have to be always made for the greater good, and unless such sacrifices are prima facie apparent and ex facie harsh and unequitable as to classify as manifestly arbitrary, these would not be interfered by the court. In view of the above, and for the reasons stated above, and as subsection 7 of 327 of the Companies Act provides that section 326 and 327 shall not be applicable in the event of liquidation under IBC, which has been necessitated in view of enactment of the new code altogether, and it applies with respect to liquidation of a company. Section 327(7) cannot be said to be arbitrary or violative of Article 21 of the Constitution of India. In case of liquidation of a company under IBC, the distribution of assets shall have to be made as per Section 53, subject to Section 36(4) of IBC in case of liquidation. In view of the above, and for the reasons stated above, the writ petition lacks merits, and the same deserves to be dismissed, and accordingly is being dismissed. So this was a Mazabia ruling judgment on this has been quite recent, 2nd May 2023, and this lays down the foundation for my today's presentation.
I have a question here.
Yes.
Now, what we spoke of is only the dues of the workmen and the employees. Their final settlement dues will get clubbed under the residuary dues, is it?
Please come again, the second sentence.
The final settlement dues, the terminal values of the, say, gratuity or
Yeah.
those things will get clubbed as a residuary due, right?
Those dues should get?
Clubbed as residuary dues.
Yes, no. See, I think you are correct. You have correctly captured what is the essence of the those welfare monies to be paid to them. You know, the terminal value would accrue only at the time of commencement of CRP if their employment is terminated, or at the time of liquidation while their employment is actually terminated by way of law. So that value would become due on the CRP commencement date or the liquidation commencement date. But the company may not be having so much fund created already for the purpose of paying to them. So the whatever value is available, whatever amount is available in the fund of the company to pay to those employees and workmen shall be paid out of that fund, and the residual value shall be taken care of under the remaining amounts as per the Section 53 hierarchy. You have absolutely correct understanding of the matter. So let me go through the preamble once, because all my presentations normally start from the preamble, but here it was important to understand Section 53 prior to starting discussion about distribution of proceeds. So I started from Section 53. Important here is that whatever we talk, whenever we talk about IBC, it always has its roots in this preamble. So today I'll again go back to the preamble and talk about two important points. Let's not read the entire thing because we are aware about it. It has been written numerous times under the code and the regulations themselves. I'll show that to you today. यही सब कुछ घूम घूम के वापस आता है during when you read the code. Here important is to balance the interests of all the stakeholders. This has been one of the objective of the code, including alteration in the order of priority of payment of government dues that we have already seen, right? So it is not just a statement to be written in the resolution plan, like we make sure at the time of due diligence or at the time of vetting of the resolution plans that whether it is written that or not, balance the interest of all the stakeholders has been taken care of. No, it is actually the most important, one of the most important objectives of the code. And secondly, to include the to create an alteration in order of priority of the government dues, which we have just seen that prior to IBC and even prior to 2013 Act, up till 1985, the government dues were given the top priority. And if anyone has a view on why government dues can be given such a low priority, they are being dealt with at the 5th number. Anyone in favor or against of that view?
Madam, the failure of Sika was just because of one of these,
Fine.
like, so far as like, getting the money, like,
But
government.
But don't you think that government dues are also important?
Yeah, it is. It is.
Yeah.
It
Then
is, of course.
why they have been given the 5th number? इतना नीचे कैसे कर दिया? क्यों कर दिया?
उनको
First
कह
step
दिया,
था.
ये कि सिक्योर्ड फाइनेंस बैंक्स का पैसा पब्लिक का पैसा है,
Right.
ठीक है,
Right.
तो उनको सबसे पहले वो,
Actual money has been infused into the
Yes.
business. Actual money, real money has been infused, and the taxes, etc. Though we are responsibly required to pay the taxes, but they are not generating money. That is not a money generated out of money. That is generated out of the operations, and one portion has to be given to the government. So it is only the government which can, for the welfare of people, can forego its right to receive the entire amount at the 1st or 2nd level. It is only the government which can afford to do so.
So it is, in other words, it is a haircut from the government department.
Absolutely, it has to take, in any matter, आप कहीं भी देखो, कोई भी government dues को हमेशा कभी top priority नहीं मिली है, except जो अभी रेनबो की वजह से क्रिएट हुआ है, and which is very soon getting amended. आपने अभी January 18th, 2023, MCA has given a discussion paper, and therein it has dealt with that subject very clearly, that there was a mistake in the language, and that needs to be corrected, because the intent was to, alter the hierarchy, not to keep the government at the first level of receiving the money from an ailing business, which is ailing already. So the actual money infused into the business belongs to the secured creditors. और उनको क्या मिलता है? 20, 30%, 40%, इतना ही मिलता है. So therefore, they have to be kept at the top. So let us quickly see what the other countries are having in their waterfall mechanism. The waterfall mechanism is also known as priority of claims across different countries. United States, Chapter 11 bankruptcy allows for the reorganization of a business. The priority of claims typically follows a specific order, with secured creditors having priority over unsecured creditors. Within the administrative expenses, employee wages, and within the unsecured creditors category, priority is given to certain types of claims such as administrative expenses, employee wages, and certain tax claims. Shareholders generally have the lowest priority. In UK, the Insolvency Act 1986 governs insolvency proceedings. The distribution waterfall provides for certain preferential claims, such as employee wages, contributions to the employee pension scheme, etc., to be paid first. Secured creditors are usually next in line, followed by the unsecured creditors. Shareholders typically have the lowest priority. In Australia, the Corporations Act 2001 outlines the priority of claims in insolvency proceedings. Similar to other jurisdictions, secured creditors generally have highest priority and over the unsecured creditors. Within the unsecured creditors category, certain claims such as employee entitlement are given preferential treatment. Shareholders are typically the last in line. In Canada, under the Bankruptcy and Insolvency Act, the priority of claims include secured creditors, certain employee claims, and certain tax claims also. Unsecured creditors are typically...
Madam, what would be your interpretation about this Canada certain employees claim?
I think I'll need to go and read the entire act.
No, and I just like,
Not open to interpretation here. I've just taken it from a summary given somewhere. I've not read the entire act, but definitely I'll read that also. Because which certain claims are they talking about? Why they have been kept in the priority in equal ranking with the secured creditors, while the other countries do not give such priority to the employee claims and the tax claims also. This is also unusual. Till now, we have been seeing the other countries wherein tax is not forming priority. In Singapore, insolvency proceedings are regulated by the Companies Act and the Bankruptcy Act. The distribution waterfall provides for payment of certain preferential claims, including employee wages, tax claims, and certain statutory claims. Secured creditors typically have priority over the unsecured creditors. So we are in line with our section 53 is in line with the international practices. The significance lies in its objective of providing a fair and equitable distribution by outlining the specific order of priority for different types of claims. It ensures that certain stakeholders are given precedence over the others. The waterfall mechanism refers to a prioritized distribution. This we are aware. I'm just leaving this slide. Objectives are to protect the rights of stakeholders, ensuring equitable distribution, balancing the interests of creditors, maximizing the asset value, and promoting transparency and predictability. Now let's see quickly the components of the section 53(1). 1A talks about CRP costs, which is defined under section 5 subsection 13 and elaborated under regulation 31 of the CRP regulations. Amount due to suppliers of essential goods and services, fee payable to AR of any class of creditors, out-of-pocket expenses of the RP, amounts due to any person whose rights are prejudicially affected due to moratorium, expenses incurred on and by the RP during the CRP, other costs directly related to CRP and approved by COC. Where expenses incurred towards or by the IRP are not ratified, the applicant must bear those expenses. Only expenses ratified by the COC shall form part of CRP costs. Interim financing and the cost thereof is already included under the definition section 5 subsection 13. What costs do not form part of CRP costs? Any fee or other expenses beyond the amount approved by the COC. Any expenses incurred by a creditor, claimant, RA, promoter, or member of the board of directors of the CD in relation to CRP. Any fee or other expenses incurred before the commencement or to be incurred after the completion of CRP. There comes liquidation cost that also forms part of 53(1)(a). Liquidation cost means any cost incurred by the liquidator during the period of liquidation subject to such regulations as may be specified by the board. And what does the regulation say? Regulations define liquidation cost as the fee payable to the liquidator under regulation 4, remuneration payable under sub-regulation 1 of regulation 7. What is this regulation 7? This is the appointment of different professionals by the liquidator. So remuneration payable to those professionals. Cost incurred by the liquidator under sub-regulation 2 of regulation 24. What is this 24(2)? This is the cost incurred by the liquidator in verifying the claims. So this is also a liquidation cost. Cost incurred by the liquidator for preserving and protecting the assets, properties, effects, and actionable claims. Costs incurred by the liquidator in carrying on the business of the CD as a going concern. Interest on interim finance for a period of 12 months. Here, there is a cap of 12 months or for the period from the liquidation commencement date till repayment of interim finance, whichever is lower. The amount repayable under subsection 3 of regulation 2A. Now, what is regulation 2A? 2A is the contribution from the stakeholders towards the, not all the stakeholders, the financial institutions, etc., who have to contribute towards the cost of liquidation, where COC has not made any provision. Any other cost incurred by the liquidator, which is essential for completing the liquidation process, provided that the cost, if any, incurred by the liquidator in relation to compromise or arrangement under section 230 shall not form part of liquidation cost. Now, this is something which needs a correction. I don't think this goes in line with the spirit of, encouraging the compromise or arrangement under section 230. The costs shall not be allowed to be liquidation costs. 53(1)(b) talks about secured creditors and workmen dues. Workmen we have read in detail already. Secured creditors. Now let's discuss about the secured creditors. They are normally the largest claimants in the resolution or liquidation proceedings, and I feel pity for them every time I read about them. Creditor means any person to whom a debt is owed and includes a financial creditor, operational creditor, secured, unsecured, and a decree holder. Secured creditor means a creditor in favor of whom security interest is created. Security interest means right, title or interest or a claim to property created. Here, the word created is important, created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance, or any other agreement or arrangement securing payment or performance of any obligation of any person. That means this security interest has to be out of some arrangement or an agreement by the CD and that other party. What are the other relevant points? An owner of an asset taken on a financial lease is not a creditor. The value of security is not the debt owed to a secured creditor in the CRP process. Then what is the difference between the value of security and the debt owed? This is also a subject matter in one of the NCLAT orders that we'll be deliberating in a shortly in a while. But anyone? Nobody? The value of security is the asset or the collateral or whatever security the CD must have offered to the secured creditor that might have a different value than the debt owed to that secured creditor. And in total, the value of security, the aggregate value of security and the aggregate value of debt might be different, and their ratios may also be different. So this is an important point. We'll come back to this in one of the in Vivek Raheja matter. Let's go to the security interest, section 52, subsection 3. Before any security interest is realized by the secured creditor under this section. So why I'm harping upon security interest so much? Because I want you to know that security interest and secured creditor, let's go back there. Secured creditor means a creditor in favor of whom security interest is created. And it is created by a transaction, right? So this forms part of the definition under the code. Now let's see what where else the security interest has been described. It is described under 52 subsection 3. Before any security interest is realized by the secured creditor under this section, the liquidator shall verify such security interest and permit the secured creditor to realize only such security interest, the existence of which may be proved either by the records of such security interest maintained by an IU or by such other means as may be specified by the board. And what the board has specified under regulation 21, which talks about proving the security interest. It says that the existence of a security interest may be proved by a secured creditor on the basis of the records available in an IU again, or certificate of registration of charge issued by the ROC, or the proof of registration of charge with CERSAI. Right? So this interest must be must be existing on the LCD or the ICD as the case may be. So whether the security interest is existing, the existence can be proved through these points. And if at all they exist, then what is the value? And up to such value, up to such interest only the secured creditor can realize. Now, coming back to 53 subsection 1 and components thereof. C is the wages and employee dues. D is the unsecured financial creditors. Unsecured financial debts have been placed prior to government dues, which were ranked first in the priority list we have just seen. Priority under subsection 1E, statutory dues. It includes dues to the central or state government, the amount to be received on account of Consolidated Fund of India. Along with this, the debts owed to a secured creditor for any amount which still remains unpaid, even after following the enforcement of security interest. Right?
Madam, one question, please.
Yes.
The related party FC is coming under clause D, unsecured financial creditors.
related or unrelated has not been covered by section 53.
Okay.
Right? So it is the prerogative of the RP, whether to admit their claims, up to what extent he admits. If the claims are admitted, then it is a prerogative of the SRA. And under the liquidation, it is a prerogative of the liquidator, whether to admit those claims or not. If at all they are admitted, then they will
Yes.
fall under secured or unsecured category.
So,
And madam, suppose I have, I have not relinquished my asset to the pool of liquidation, right?
Right.
So suppose I have chosen to, sale of my own, but I have realized less value than what my dues were.
You have
But in that, suppose I hold an asset like, which was charged for rupees 100. Okay. So I decided to sell this asset outside the liquidation state.
Right.
In that process, I received 60 rupees.
Okay.
So how this 40 rupees to be treated in other?
So your admitted dues were rupees 100.
Yes.
Right? You have realized by selling your security interest, you have realized 60 rupees. So your 40 will come under 53(1)(e) subclause 2. Debts still owed to you for the amount which is remaining unpaid following the sale of your security interest. Here, secured creditor shall mean those who have realized out of the liquidation process and not relinquished their rights in favor of the liquidation pool, the liquidation estate. FGH, we are aware, residual dues, all other dues and debts, for example, operational debts owed to unsecured creditors, etc., etc. Preferential shareholders, by nature of priority in dividend, they are given priority over the equity shareholders. Important is also to look at section 178. It is for the individual and partnership firms, and chapter 5 deals with the distribution of the estate of the bankrupt. Priority here is almost similar to section 53, notwithstanding anything to the contrary contained in any law enacted by the parliament or the state legislature for the timing in force. In the distribution of the final dividend, the following debts shall be paid in priority to all other debts. So till here, the language is quite similar. Firstly, the cost and expenses incurred by the bankruptcy trustee for the bankruptcy process in full. Secondly, the workman's dues for a period of 24 months preceding the bankruptcy commencement date and debts owed to secured creditors, absolutely similar. Thirdly, the wages and any unpaid dues owed to the employees other than the workmen of the bankrupt for a period of 12 months preceding the bankruptcy commencement date. Fourthly, any amount due to the central government, state government, including the amount to be received on account of CFI or CF of a state, if any, in respect of whole or any part of period of 2 years preceding the bankruptcy commencement date. Lastly, all other debts and dues owed by the bankrupt, including the unsecured debts. The debts in each class specified in subsection 1 shall rank in order mentioned in that subsection, but debts of the same class shall rank equally amongst themselves and shall be paid in full unless the estate of the bankrupt is insufficient to meet them, in which case they shall await in equal proportions between themselves. Where any creditor has given any indemnity or has made any payment of monies by virtue of which any asset of a bankrupt has been recovered, protected or preserved, the AA may make such order as it thinks just and with respect to the distribution of such asset with a view to giving that creditor an advantage over the other creditors in consideration of the risk taken by him in so doing. Unsecured creditors shall rank equally amongst themselves unless contractually agreed to the contrary by such creditors. Here, there is a difference. The contract between them will be regarded, will be given importance to. Only difference between 53 and 178 lies here, that the unsecured creditors shall rank equally amongst themselves unless there is some contractual relation amongst them which has been agreed to the contrary by such creditors. Any surplus remaining after the payment of the debts under subsection 1 shall be applied in paying interest on those debts in respect of the periods during which they have been outstanding since the bankruptcy commencement date. Now, what is the relevance of liquidation value under IBC, CRP regulations and liquidation regulations? IBC talks about it under section 30. Why liquidation value? I'm taking care of this subject because you are aware that under resolution plan as well as at the time of section 53 disbursements distribution, the value whatever we arrive at has to be looked at from the perspective of the liquidation value. The RA may submit a resolution plan with an affidavit stating so and so. The resolution professional shall examine each resolution plan received by him to confirm that each plan provides for a payment of CRP costs in a manner specified in priority to the payment of other debts. It provides for payment of debts of OCs in such a manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors, such OCs, in the event of a liquidation of the CD under section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the plan had been distributed in accordance with the order of priority in subsection 1 of 53, whichever is higher. So this they have to actually write and provide for. That at a later stage, if it is found out that the liquidation value and their proportion in that value is higher, then that amount would be paid by the RA to the OCs, and provides for payment of debts of FCs who do not vote in favor of the resolution plan in such manner as may be specified, which shall not be less than the amount to be paid to the creditors in accordance with subsection 1 of section 53 in the event of a liquidation of the CD. Now here, the FC has a choice. FC has a choice of exercising dissent of not to vote in the favor of the plan or to dissent to the plan. Both of them would have the same treatment with them. Thereafter, second choice he has is to realize his security interest. And the third is at the time of liquidation, he will, if no plan is getting approved at the time of liquidation, he will be paid under 53(1)(b). So while exercising the options, what an FC should be taking care of, and in case you are an advisor to an FC, you are in a legal capacity, you are an advisor to an FC, you must protect their rights considering the value, whichever is being offered as a liquidation value, their share in the liquidation value, because 2B proviso to this 2B talks about that in case they do not vote in favor of the plan, or they do not vote at all, means they abstain or they dissent, then they will be getting the liquidation, the value which would have been given to them under 53(1)(b). And second option is to realize their security, just not let the plan get approved and realize the security under 52. That may be a value given to them. So these options must be exercised by the FCs, and the best of them should be exercised. The resolution professionals shall present to the committee of creditors for its approval such plan.
Madam, just a minute, sorry to interrupt you.
Yes.
So actually you were just asking us just to give the kind of advice to your the financial creditors creditor.
As not as an IRP or RP or
Yes, in the capacity.
not
of
in
course.
that capacity. Yeah.
So how would you you can just clarify this by way of example from your side?
Yes. In case they have a security interest, for example, they have an interest in a property, in a plan is offering them certain value. For example, 20 CR is being offered by the plan to a certain secured financial creditor, and they have a security over a property which, if sold, will give much higher value. Then definitely it is a very clear comparison. But in case they do not vote in favor of the plan and ultimately they are getting paid only the liquidation value or the value which would have been paid to them had there been the distribution as per section 53, that is what this proviso tells about. in case the distribution is under 53(1)(b), then whatever their share would be given to the dissenting person. So they need to exercise whether to sell the asset they have as a security interest, whether to go by whatever is being offered in the plan, or to insist for liquidation. So there are three values available to him. Right?
But suppose you dissent, so your voting is not counted.
Then you don't have that option only, na? You exercise the option when it is available to you.
Okay.
Yeah. The committee of creditors may approve a resolution plan by a vote of not less than 66% of voting share, but after considering feasibility and viability, वगैरह वगैरह ये हमको पता है. But important is the manner of distribution proposed. So COC will definitely look at their own share, which may take into account. This may take into account has still given some leeway in the hands of COC to not to go by the 53 hierarchy, but I have seen in all the cases, the distribution is in the same manner. Generally, the 53 is given respect to. And very soon the amendment has been proposed. The latest discussion paper has proposed an amendment about this resolution plan distribution manner or under the resolution plan also. The manner of distribution proceed which may take into account the order of priority amongst creditors as laid down in subsection 1 of 53, including the priority and value of security interest of a secured creditor and such requirements as may be specified by the board. So requirements are specified by the board under regulation 37, 8, 9, we are aware. The amendment which I was talking about here is coming in, I think, further slides. I'll just see where that has gone, or we'll take up as and when it comes. Next is the appointment of liquidator and the fee to be paid. So important points amongst that under this section is an insolvency professional proposed to be appointed as a liquidator shall charge such fee for the conduct of liquidation proceedings and in such proportion to the value as may be specified by the board, and that is specified under liquidation regulations. An entire chart has been prepared on when and how he can take his fees out of the proceeds of the realizations of the sale of assets. The fees for the conduct of liquidation proceedings under subsection 8 shall be paid to the liquidator from the proceeds of liquidation estate under 53. Now, what is liquidation estate? For the purpose of liquidation, the liquidator shall form an estate of assets mentioned in subsection 3, which will be called liquidation estate in relation to the CD. Liquidator shall hold the estate as a fiduciary for the benefit of all the creditors. Subject to section 4, the estate shall comprise all liquidation estate assets, which shall include any assets over which CD has ownership rights, including all rights and interests therein as evidence in the balance sheet of the CD, or an IU or records in the registry, or any depository recording securities of the corporate debtor, or by any other means as may be specified by the board, including shares held in any subsidiary of the CD. Assets that may or may not be in possession of the CD, including but not limited to the encumbered assets. Tangible assets, whether movable or immovable. Intangible assets, including but not limited to the intellectual property, securities, shares held in a subsidiary, and financial instruments, insurance policies, contractual rights, etc. Assets subject to the determination of ownership by the court or authority. Any assets or their value recovered through proceedings for avoidance of transactions in accordance with this chapter. Any asset of the CD in respect of which a secured creditor has relinquished security interest. Any other property belonging to or vested in the CD at the insolvency commencement date, and all proceeds of liquidation as and when they are realized. Very important section, section 36(4), which talks about what assets are not included in the liquidation estate assets and shall not be used for recovery in the liquidation. The assets owned by a third party which are in possession of the CD, for example, assets held in trust for any third party, bailment contracts, sums due to any workman or employee from the PF pension fund and gratuity fund, other contractual arrangements which do not stipulate transfer of title but only use of the assets, and such other assets as may be notified by the central government in consultation with any financial sector regulator. The assets in security collateral held by the financial service providers and are subject to netting off and set off in multilateral trading or clearing transactions. Personal assets of any shareholder or partner of a CD, as the case may be, provided such assets are not held on account of avoidance transactions that may be avoided under this chapter. Assets of any Indian or foreign subsidiary of a CD, or any other assets as may be specified by the board, including assets which could be subject to set off on account of mutual dealings between the CD and any creditor. Have you noticed this set off has come 3 times under the liquidation provisions, code, regulations, all talk about the mutual set off. But earlier, the CRP regulations and the CRP procedure were silent on set off. So this has also been incorporated now under the relevant form, and very soon it shall come under the as an amendment also. CRP regulations talk about the liquidation value. It means the estimated realizable value of the assets of the CD if the CD were to be liquidated on the ICD. While approving a resolution plan under subsection 4 of section 30, or deciding to liquidate the CD under 33 subsection 2, the committee may make a best estimate of amount required to meet the liquidation costs in consultation with the RP. The committee shall, now committee may make an estimate of the amount required to meet the cost, but the committee shall make a best estimate of value of liquid assets available to meet the liquidation costs, and where the estimated value of the assets is less than the estimated costs, the committee shall approve a plan providing for contribution for meeting the difference between two. And where the committee does not make any such estimate under subsection 1, then it goes under 2A of liquidation regulations. The RP shall submit the plan approved under subregulation 3 to AA while filing the approval or decision of the committee under 30 or 33 as the case may be. For the purposes of this regulation, liquidation costs shall have the same meaning as assigned to it under EA of 2(1) that we have seen already. Now, very important section, section 52, which is at the core of today's discussion, and I find secured creditor to be in the best and as well as in the worst position under the IBC. A secured creditor in the liquidation proceedings may relinquish its security interest to the liquidation estate and receive the proceeds from the sale of assets by the liquidator in the manner specified under section 53, or it may realize its security interest in the manner specified in this section 52. Where the secured creditor realizes the security interest under clause B of subsection 1, he shall inform the liquidator of such security interest and identify the assets subject to such security interest to be realized. Now again we come to the same section which we have read before. Before any security interest is realized by the secured creditor under this section, the liquidator shall verify such security interest and permit the secured creditor to realize only such security interest, the existence of which may be proved either by the records of the security interest maintained by an information utility or by such other means as may be specified by the board. And what has the board specified in this case? The charge created by ROC, certified by the ROC as such, and thirdly, the CERSAI. Right? So 3 points are given under regulation 21A, which we have just read. So those 3 also substantiate the existence of the security interest, and only thereafter liquidator shall permit the secured creditor to realize only that portion of the security interest which will be substantiated by such means which are.
So that means, madam, it is settled law. Suppose security interest has been created, but no charge has been registered. So that asset cannot be
sold by that secured creditor. You will not consider that creditor to be a secured creditor up to that extent.
And suppose the if we apply for condonation of delay in filing and registration of charge.
No,
Then in
that
that
cannot
case-
be created once the moratorium applies. No, you cannot create further charge on the property of the CD. The
No, but
assets are-
charge I cannot create, but if this charge was existence prior to that.
how will you prove? How will the creditor prove that? It has to be proved under these 3 points only, either record at the IU or at ROC or at the CERSAI. You cannot treat that secured creditor by providing a record or providing a supporting document which is dated later than the LCD or the ICD.
So that means how this IU and the CERSAI will take up all these kind of cases unless until the charge has not been registered or it has
I
not
will,
been.
they
it has
will
been
take, they have their own process where the charge is uploaded over there. That process has to be followed by all the charge creators. Once the charge has been created, either it will go to MCA or to
Madam,
CERSAI.
Madam, creation of charge is something different than registration of charge.
But registered charges are only considered as
Okay.
security interest. The liquidator has no power to consider a security interest or a creditor as a secured creditor unless there is a record, there is a registered record given by a third party to that creditor. A certificate maybe, or a record at IU.
Suppose I give a document, okay, which is an unregistered document to IU. Will IU will accept this, or the CERSAI will take note of it?
We will
And
have to go through the IU regulations separately for this purpose, which I have not, sorry. Next time in this presentation, I'll read them as well. Because IU is also providing certain conditions prior to registering any information, you know, thousands of information, thousands of data is being uploaded at IU. And IU takes its own steps while verifying and uploading, before uploading that data on its own websites.
So there was always a confusion between the creation and the registration.
But confusion here by way of section 52, which is provided right in the code itself, right? So it is not a regulation which could be, you know, written by somebody. Code says that it has to be as per the means specified by the board, and only then the liquidator will permit. Liquidator shall verify and permit the secured creditor only such security interest, the existence of which may be proved by the record of IU or regulation 21, which says record available on IU, certificate by ROC, or proof of registration with Central Registry of Securitization. So secured creditors should be aware about this.
That means registration is compulsory, to put it in
Yes.
another way around this.
Yes, and even an RP should not consider a secured creditor as a secured creditor unless he gets one of the proofs out of these 3. So let's go on 4th. A secured creditor may enforce, realize, settle, compromise, or deal with the secured interest assets in accordance with such law as applicable to the security interest being realized and to the secured creditor, and apply the proceeds to recover the debts due to it. If in
Madam, what does compromise mean here? In the previous slide, please.
Realize, settle, or compromise. Compromise might mean assignment, or maybe selling, reducing its own title. Compromise to title se hoga na, ownership of the interest in that secured asset.
Compromise, that means you're going to settle by way of other means, you mean to say that?
Settling, selling, assigning, everything is covered under this.
Compromise.
Not compromise. Selling is realizing. Settling is settlement amongst, settling it by means of this I'm not readily having any answer. Compromising means compromising.
Settling might be like, you know, you're accepting less than that what it is, like, you know, offered
Whatever
by
is
the
available, whatever value is available to settle for that.
Madam, we can also settle with the CD and withdraw the application.
No, that is not covered here.
Otherwise, it could be an
Settling
one-time
means-
settlement, ma'am.
No, that is not covered under this clause. Here we are talking about compromising of the title to that secured asset, maybe. The secured asset may be transferred to someone else, or the recoverables you may be having right over the actionable claims, and you may compromise your title. You may compromise your right to recover those.
Yes, compromise right by way of
Compromising
means.
your right to recover, compromising your title to that asset. So that is what is covered under here.
Thank you, madam.
If in the course of realizing a secured asset, any secured creditor faces resistance from the CD or any person connected therewith in taking possession, selling, otherwise disposing of the security, the secured creditor may make an application to the AA. The AA, on receipt of such an application, may pass such order as may be necessary to permit a secured creditor to realize the security interest. Where the enforcement of security interest under subsection 4 yields an amount by way of proceeds which is in excess of the dues of the secured creditor, the secured creditor shall account to the liquidator for such surplus, tender to the liquidator any surplus funds received from the enforcement of such secured assets. The amount of insolvency resolution process costs due from the secured creditors who realize their security interest in the manner provided in this section shall be deducted from the proceeds of any realization by such secured creditors, and they shall transfer such amounts to the liquidator to be included in the liquidation estate. Where the proceeds of realization are not adequate to repay the debts, as we discussed earlier, the unpaid debts of such secured creditor shall be paid by the liquidator in the manner specified in clause E of subsection 1 of 53. That is ranking equally with the government dues. This we have already seen. 21A. Now we are generally not able to implement this 21A. Has anyone faced difficulty in presumption of security interest practically? It talks about where a secured creditor does not intimate its decision within 30 days from the liquidation commencement date, the assets covered under the security interest shall be presumed to be part of liquidation estate. What stops us from this presumption?
Ma'am, if there is a registered charge, but though the secured creditor has not responded within the prescribed period, but if the charge is already registered, then there is no question of deemed secured interest. It's already a registered interest.
Yeah. Anything else?
I mean, when this provision is there, just within 30 days, the liquidator has to wait for their decision to
Liquidator
come.
तो wait करता रहता है. हम तो 2-2 साल भी wait किए हैं हमने तो.
नहीं, अब तो नहीं है ना मैडम. 30 डेज के बाद में वो तो पहले का था ना. अभी तो 30 डेज में.
नहीं, they do not. They do not convey.
May I say this, ma'am?
See, madam, conveyance is something different. By deeming provision, you have all the right to claim to that property.
There is something, Rajkumar ji.
May I say this?
Hanji.
Section 69A of Transfer of Property Act will come into play if the liquidator, that is a security creditor, relinquishes, realize its security interest in the way they want by invoking section 52 rather than going behind the section 53. If they fail to intimate within a stipulated period, then there is a general presumption drawn in favor of the liquidator that it might be part of the liquidated estate.
Okay, that is
It
also
could be a possible reason.
Yeah, that is also a valid point, a practical difficulty. And let's come back to our own IBC. The regulation 32, the proviso to this regulation, this is a very important regulation for selling of the assets under liquidation, but the proviso says, where an asset is subject to security interest, it shall not be sold under any of the clauses unless the security interest therein has been relinquished to the liquidation estate. And this talks about a clear relinquishment, and that has to come by way of intimation by the secured creditor. You know, that decision has to be taken by them and clearly intimated to the liquidator. This regulation stops you from selling any asset. So even if you presume, you cannot sell. Right?
That means, like, we have to take the custody of that property as a custodian till you receive any concrete mandate from the secured creditors.
But the liquidation proceedings cannot take place, you know. आपको liquidation में करना क्या होता है? अपनी reports file करने के अलावा you have to just sell the assets. And in case you are not able to sell the asset, there is a restriction in the regulation itself. You cannot sell. So
तो
that's
तो मैडम 65 में हम वो ले सकते हैं ना?
आप ले सकते हैं, आप possession ले सकते हैं, लेकिन एक amendment आ रहा है for this purpose only. It is being considered that the code may restrict the secured creditor's right to either realize or relinquish within a specified period only. Then thereafter, this will be amended. This regulation 32 will have to be amended. Also, it may be clarified that where secured creditor do not convey their decision to the liquidator within this period, they shall be deemed to have relinquished. Then this proviso will have to be removed from here.
Then, madam, how to deal with the existing cases like this?
Existing cases are in limbo. We are just requesting them. We are just writing mails to them and filing applications. You know.
So how your dissolution will take place then?
Dissolution तो दूर की बात है, selling ही नहीं take place होता ना.
तो मैडम अभी दूसरे तरफ में आपका 1 year का mandate दिया, you are also not complying with that.
That is where you have to tell them the law. उनके पीछे पढ़ के उनसे डिसीजन निकलवाने पड़ते हैं.
मैडम अकाउंट तो क्लोज करना बहुत मुश्किल होता है, अकाउंट तो क्लोज नहीं करते.
तभी तो लिक्विडेशन के मैटर्स इतने साल से चल रहे थे. अभी तभी तो दिस लूपहोल हैज कम इनटू पिक्चर. अभी अमेंडमेंट विल टेक प्लेस.
ओके.
हाँ जी. So where a secured creditor proceeds to realize its security, it shall pay as much towards the amount payable under clause A and subclause 1 of clause B of let me see if anyone has dealt with this situation where a secured creditor has sold the asset, the secured asset. If you can tell your experience.
Secured selling of assets by the secured creditors by their own.
Yes.
Okay.
This is a very interesting regulation. Why it is interesting? Because this one regulation 37 is so interesting. इतने दिन में ये करना है, इतने दिन में वो करना है, और it goes on like that. And while I was stuck in this for one of the matter where a car was being sold by the banker who mortgaged that car. वो प्राइस लेके आ रहा है, मैं प्राइस लेके आ रही हूँ, and this war was there, this fight was there. उनके ऑक्शन हो रहे हैं, अपने हमारे हो रहे हैं, तो we were bringing the best value. हमें वो तो this actually happens, and it is quite interesting when you deal with a secured creditor. और regulation 37 is a must read for all of us. It gives some relief कि इसमें ऐसे मजाक भी कर रहे हैं in the procedure itself. अच्छा चलो वापस आते हैं. Where a secured creditor proceeds to realize the security interest, उसको सबसे पहले क्या देना पड़ेगा? When they proceed to realize their security interest by selling the secured asset, it shall pay what?
Liquidation cost.
Yes. और कोई unpaid CIRP cost है तो वो
Yes.
भी देना पड़ेगा. What else? Something else?
Cost towards selling the asset.
No,
No.
it is written right there. See, the amount payable under clause A. Clause A is what? Clause A is the CRP and liquidation cost. And subclause 1 of clause B of subsection 1 of 53. 53(1)(b)(1) क्या है? That is the workman dues. Workman dues का certain portion is there. The secured creditor has to pay that also. The subclause 1 of clause B of subsection 1 of 53. That is the workman's share, as it would have shared in case it had relinquished the security interest to the liquidator within 90 days. उसको ये दोनों चीजें pay करना होता है. One is the portion of CRP or the liquidation cost, and second is the workman's share in that security, as it would have shared in case it had relinquished the security interest to the liquidator. Second, उसको क्या देना होता है? The excess of the realized value, if any, over the amount of his claims to the liquidator within 180 days of the liquidation commencement date. Provided that where the amount payable under this sub-regulation is not certain, by the date the amount is payable under this regulation, the secured creditor shall pay the amount as estimated by the liquidator. So CRP or liquidation costs are not certain, then it will be paid on an estimation basis. Provided further that any difference between the amount payable under this sub-regulation and the amount paid in the first proviso shall be made good by the secured creditor or the liquidator, as the case may be, as soon as the amount payable under this sub-regulation is certainly known, that is the cost. It is hereby clarified that the requirements of this regulation shall apply to liquidation processes commencing on or after the 25th July 2019. This amendment came, and after that, whichever processes commenced, this regulation was applicable on them. A secured creditor who seeks to realize its security interest under Section 52 shall intimate the liquidator of the price at which he proposes to realize. This is the procedure now. The liquidator shall inform the secured creditor within 21 days of receipt of the intimation if a person is willing to buy the secured asset before the expiry of 30 days from the date of intimation of the sub-regulation at a price higher than the price intimated under sub-regulation 1. Where
Madam, sorry to interrupt
Yeah.
you here.
yeah, no problem.
Suppose I have received the claim from the security holder. Okay, I mean,
Secure, okay.
okay, but at the time when you make the public announcement for under the liquidation process, then you receive all this kind of claim, like, even from a secured creditors who wants to go for 52 or 53. Suppose 52%, I mean, the secured creditors in that form itself mentions that, okay, they are not willing to, I mean, put that asset into the liquidation state, right? In that form itself. So from there onwards, like, this all, I mean, initiation of process, then?
No. From there, you will not calculate that, you will not include that in part of in your liquidation estate. Thereafter, the secured creditor will have to inform you the price at which he proposes to sell that asset.
Okay,
And
within
from
how
there,
many?
the
Within,
timeline will start.
yeah, great. Within how? What is the timeline for that? For informing that secured creditors to the liquidator?
This must be under Section 52. Let's go back to that. Let's
45
see.
days?
No, that timeline is not given. But let's assume it should be 30 days because within 30 days, he has to intimate it decision under 21A.
डिसीजन तो उसी समय हो जाता है मैडम, फॉर्म में डिसीजन दे देते हैं वो लोग.
हाँ, so I think it should not be more than 30 days that he has to take this step to intimate the price at which he proposes to sell. That must be within 30 days of the liquidation commencement date, in case he has given in the form itself. Because that timeline is not clearly given under this regulation. Hereafter, the timelines apply. Okay.
Yes.
Now, liquidator ने उसको अपना price बता दिया. Where the liquidator informs a secured creditor of a person कि मेरे पास एक buyer है who is willing to pay a price higher than your buyer. So secured creditor will have to sell the asset to that person. Other liquidator does not inform the secured creditor, then the person does not buy the secured asset in accordance with this regulation, then secured creditor may go on and realize the security interest in the manner it deems fit, but at least at the price intimated originally by him. Where the
Madam, won't be it would be contradictory to the mandate that you have at the one side you are giving the mandate to the secured creditors to relinquish their security of their own. At the same time, at a later stage, liquidator comes into picture and asking for more price.
No. Liquidator is not asking for more price. Liquidator is only informing him that I have a buyer who is willing to pay a higher price than your buyer. So you may get a better price.
Is a bargaining or?
No, it is given under the provisions. That's what I told. No, this regulation is very interesting. Secured creditor is allowed to sell, but he will have to sell it at a price which is higher than any other available buyer. And in case liquidator has a buyer who is willing to pay a price higher than this, then the secured creditor will have to sell to that person only.
So, madam, what was the end of your story, like, selling the car where the tussle were going on?
The bank took it.
The bank took it.
Yeah. But there, at that time, I read this regulation. I found it very interesting. So where the asset is realized under subregulation 3, the creditor will bear the cost. Where the asset is realized under subregulation 4, the liquidator will bear the cost to identify the buyer and sell. So the provisions of this regulation shall not apply if the secured creditor enforces his security interest under SARFAESI. Right? A secured creditor shall not sell or transfer an asset which is subject to security interest to any person who is not eligible under the code to submit a plan for CRP. So this due diligence will have to carried out by the liquidator at the same time. So he will have to bring the buyer on table. Disclaimer of onerous property. So this is also one of the method available for certain properties which you are not for which there is no claimant. Where any part of property or of a CD consists of land, shares, or any other property which is not saleable or not readily saleable by reason of possessor thereof, being bound either to the performance of any onerous act or to payment of any sum of money or unprofitable contracts. The liquidator may, notwithstanding that he has endeavored to sell or has taken possession of the property or exercised any act of ownership in relation thereto or done anything in pursuance of the contract, may make an application to the AA within 6 months from the liquidation commencement date or such extended period as may be allowed by the AA to disclaim the property or contract. Otherwise, वो इसको लेके बैठा रहेगा उस burden के साथ, उन covenants के साथ, and he will not be able to wind up and dissolve the company. So this is the procedure given under regulation 10. Now, shall we take a break for 15 minutes? Is Anjali there?
Sure, ma'am, we can take the break.
Let's come back in 10 minutes, right?
Okay, ma'am.
3:55 will join.
Sure, ma'am.
Thank you. let's start. Are we there?
Yes, ma'am.
Yes, we are all there.
Thank you. At least I could hear 3 people. Till now, I thought I am speaking to 2 people only.
No, no, no.
All right. So there is a provision of early dissolution under our liquidation proceedings. And at any time after the preparation of the preliminary report, if it appears to the liquidator that the realizable properties of the CD are insufficient to cover the cost of liquidation process, and the affairs of the CD do not require any further investigation, he may apply to the AA for an early dissolution of the CD and for necessary directions in respect of such dissolution. We have spoken about this regulation, but it is very important from the sale perspective. Thereafter, only the proceedings shall actually start. The liquidator may...
Madam, just a minute. I'm so sorry.
Yeah.
I just missed out your last conversation about the early dissolution. Application for early dissolution.
See, if the property, the realizable property is not having that much value, if the liquidator considers that there is not much of a realizable value that it shall cover the cost of the liquidation proceeding, and the affairs do not require any further investigation, and there has not been any avoidance transaction prima facie, you could not find an opinion, form an opinion regarding that. You think that an early dissolution would be a better idea to save costs and not to go for the entire liquidation proceedings after preparation of your preliminary report. For example, if you find that there are no assets owned by the company and the assets are only owned by the shareholders or the promoters, which have been already secured with the creditors. So the liquidator does not have much to do in that company. You can quickly sell, or if there are no assets, sometimes there are companies which reach to the liquidation and there are actually virtually no assets to be sold. Then you can directly apply for a dissolution.
And suppose, madam, there are certain PUF transaction, pending during the CIRP.
Which transaction?
PUF transaction.
Okay. So then
in that case can be considered.
No. Then you will need to go through the entire liquidation proceedings, and side by side you need to carry out the previous applications, if any, filed by the RP. And in case the RP has not, because there has not been any successful RA, so the RP must have handed over that application to you, and the liquidator will have to take care of that application. And at the time of filing of this dissolution application, you will file a detailed report on how the application will be carried over after the filing of dissolution by you. Once
so madam, this early dissolution can also be considered during CIRP time when there is no much asset available.
Yes. There is a provision of I think early liquidation in that, but I'm not sure of the section right now.
Yeah, you're correct. That is the early liquidation.
Early liquidation, right? So here you can directly go to the dissolution and fulfill the requirements related to the dissolution right away when you don't have anything to sell under these sections. If there are no assets or no liabilities for to be taken care of, then, and in case the costs are much higher, or there is no realization from any sale of assets to take care of your costs or the liabilities or the claims, etc., then why to carry over the process? Keep filing the reports only. So where there are the assets available to be sold, they can either be sold on a standalone basis, lump sale basis, set of assets, parcel, going concern, etc. So it is very important for a liquidator, because in most of the cases, the valuation has been done by the valuers under section 29 and not 29, under the section 35 of CRP at the time of CRP. And by the time you start realizing your assets under liquidation, in case the substantial time has elapsed between them, then regulation 35 subregulation 2 also provides an opportunity to it allows the liquidator to go for a fresh valuation of assets. And in that case, I always advise the IP friends that in the case of liquidation, you must avail that option available to you. You must get a fresh valuation done, because at the time of CIRP and by the time you start selling the assets, there is generally a gap of 1.5 years minimum. Normally there is more gap than that, but even after 1.5 years of no operations and no maintenance, no proper maintenance is if carried out, then assets depreciate a lot, and then you will have to answer at the end of the procedure. You will have to answer why this has been sold at such a value, why book value was this, and you are selling the asset at this price. So a valuation done in the right spirit.
Madam,
helps
in
you.
in either of the case, like, IPs are being questioned, even if you go for valuation and not go for valuation. If
No,
you
no,
go
no.
for
Going for valuation, you must have a justifiable case. In case, like in one matter I dealt with, in one matter, there was a gap of 3.5 years between the one valuation and the valuation that we ordered. We started at the time of liquidation because of the non-communication by the bank to us regarding their relinquishment. We could not proceed at all in one of the liquidations. By the time we Ashok ji. So by the time we started selling, we were in a position to sell. We were not having the correct values in hand. And at that time, the valuers were given a strict mandate to give the valuation under these heads so that we could take a decision, because sometimes we are not knowing technically what could be the best value we can fetch by selling the asset in which manner. So the manner of sale has to be out of these 5-6 options. So these 6 options must be told and explained to the valuer, and he should give his report accordingly. Why is it not moving?
Madam, just one question, please.
Yes.
At what point of time the valuation report shall be disclosed to the COC?
Which report?
Valuation report.
Valuation report is not generally shared,
Yes.
We are not actually required to share the valuation reports. Under no matter I have seen sharing the valuation report by the RP with the COC, but you have to give a summary or a value or the average of the valuations that have come to you at the time of giving of a placing of the compliant resolution plan, whichever the plans which are complying with the law. At the time of placing those plans, you must tell the valuation to the COC after taking confidentiality undertaking from them.
That means
is
before the resolution plan is received.
The plan is placed. You have done the due diligence of the plan. You have found out which plans are compliant and which plans you are going to place at the COC meeting. You are going to give to the COC. At that time, you need to tell the average valuation to them under each category. Two valuers of each category you have appointed. You have come to know about two values under each category, and the average of the values you need to tell to them. That too, after taking the confidentiality undertaking from them. That is what the law says. And law ke beyond jo kuch karte hain to kar hi lete hain. But I have not seen any RP doing that, because that has a lot of बहुत दारोमदार उस वैल्यू पे डिपेंड करता होता है, तो वो सीधे सीधे ऐसे ही डिस्क्लोज नहीं कर देना चाहिए. And simultaneously, along with the resolution plan, वो भी वो plans जो compliant है, on which you have carried out a due diligence, so that later on आपको उन plans को भी वापस ना लेना पड़ जाए. तो आप only compliant plans को place करते हो और उस time पे values का average उनको बता देते हो only to the COC, and you are not bound to give the valuation का average to the promoter also. But while we place it at the meeting, we take it on record, then the promoter also comes to know about it.
Madam, it is the entire, whether it is the entire report to be shared or just the gist of
only the average of the valuations need to be shared.
Okay, then the resolution plan is not received and the company goes to liquidation. At what point of time is there?
At what? Sorry.
If the resolution plan is not received and the company goes to liquidation, at what point of time that will be shared to the stakeholder committee?
in the first meeting itself, you can share. Then stakeholder committee is not, having the same interests in as the COC was having. So there are no RAs coming over here. So here the valuations you can share, but even here the regulations or the code does not ask you to do so. You cannot be compelled to share the valuation reports. You can only give the average of the valuations to the SCC also.
Okay, okay.
Madam, what about sharing of minutes of SCC with the stakeholders? Because I had read somewhere that you need to have a
You
undertaking.
need to, yes, you need to now share the minutes in exactly the same manner as you were doing with as you have been doing under CIRP, because with the effect from 16 September 22 amendments, drastic amendments have been carried out under liquidation regulations also, and छोटे से print में लिख दिया गया है कि all the sections so and so will apply to SCC meeting as well. So now whichever, वहां पे भी एक कैच है, जो लिक्विडेशन मैटर्स पहले से चल रहे थे prior to 16 September 22, on them these regulations will not apply, but certain companies, certain liquidators had started following the 25th July 2019 ka amendment, and those who have followed the 25th July 2019 amendment by whatever way, mandatorily or voluntarily, and they have formed an SCC, then they are required to follow the 16 September 22 ka amendment by virtue of that SCC that they already have constituted.
That means what is the correct position of law as on date after this amendment? We need to have an undertaking.
Yes, all the provisions of CRP apply to, all the provisions applying to the COC apply to the SCC as well. And we are required to share the minutes.
Madam, you mean to say that for for every minutes you need to have, or only one time you have to have that 29A compliance undertaking?
29A compliance we are not talking.
No, I'm not talking about 29A. I'm talking about the undertaking while submission of minutes.
No. Now confidentiality is not required. You need to share the minutes.
Okay.
Yeah.
That is the earlier it was.
Earlier it was. Okay, so we go back.
Another question, please.
Yes.
I have constituted one COC. There were one financial creditor, NBFC. Then one operational creditor, government department, government GST. One related party financial creditor. The financial creditor, NBFC, had only 100% voting power, but they had 20% of total claim, 10% total claim. And the operation.
Please, can you please repeat? Sorry.
Okay. Yeah. There are financial creditor. Financial creditor who is a NBFC, is operational creditor, that government department. Okay. Then one is financial creditor who is a related party.
Okay.
There are three.
Financial creditor is NBFC. Thereafter,
operational creditor, government department, GST department.
Okay.
And another is financial creditor, related party.
And you have admitted the claims?
Yes.
Okay.
Then the COC was constituted and everything was going right. And after that company goes to liquidation. So when the company is going to liquidation, that financial creditor having 100% voting rights is not remaining present in the in the meeting. What shall the liquidator will do?
Liquidator, are we talking about COC or
yes,
SCC?
Yes, COC. Then the CRP was completed.
Okay.
Went to liquidate.
The same people became the part of SCC.
Yes.
Then liquidator will have to go to the NCLT asking for suitable directions. because not attending the meeting will not, allow him to proceed. And whatever is stopping you in carrying out your duties as a liquidator, you will have to go back to the adjudicating authority for seeking proper directions. In whosoever is not cooperating with you and whosoever is not abiding by the law, it is their duty as well to attend the meetings.
Their voting rights will be continued as was in CRP period.
Their voting rights, if there is no change in the SCC, if you have not received any further new claims at the time of liquidation, which are there at the time of liquidation commencement date, if there is no change, then the same people, same voting rights will continue. In case you have a different stakeholder added to the list, or the amounts are changed, then the voting will change.
Okay.
It has to be as on the date of liquidation commencement date. So you will need to take the claims and check in terms of the newly constituted. Your liquidation started after 16th September 22?
Yes.
Yeah. So just go through the regulations once, and you will need to reconstitute your SCC. You may or may not be having the same people and the same voting right as you were having under COC. And the amounts shall depend on the amounts of claims submitted by them as on the liquidation commencement date. So that makes the difference.
Okay.
Because some interest may be added. Sorry, yes?
Ma'am, can I ask a question?
Yes, yes.
Ma'am, actually, my liquidation was started on 2019. And at the time of CIRP period, there were claims. But at the time of liquidation, claim has been rejected because it was delayed submission. So, ma'am, after September 2022, should I reconstitute the stakeholder committee or
yes, you should.
But ma'am, it should be done within 60 days. But now it is more than 7 months.
See, if you genuinely think that the claim should be considered, you can help the claimant informing him about section 42. It is section 42 or regulation 42, wherein he can go against, file an appeal against the liquidator and get the claim admitted. So the NCLT gives a direction to the liquidator to admit the claim on merit basis. So it is never too late. Right? They can go through that section 42 and file a complaint, an appeal against the liquidator. It's called an appeal against the liquidator for getting his claim admitted, and you can thereafter you can admit. NCLT will direct that you admit it on merits, and you will check the documents, and then you will, if they are okay, you will admit.
Okay.
Yeah. We go back. My presentation will not get over today. Okay. So sale as a going concern में एक question है अच्छा. I'll also ask something. अगर you have to, चलो first we read this. Where a committee of creditor has recommended sale under clause E or F. E था to sell the company as a going concern, F था to sell the business as a going concern. और या तो COC ने recommend कर दिया है, or where the liquidator is of the opinion that sale under clause E or F shall maximize the value of CD, then the liquidator shall endeavor to first sell under the said clauses. For the purpose of sale under this sub-regulation, the group of assets and liabilities of the CD as identified by the COC under sub-regulation 2 of 39C, हमने पढ़ा था अभी, shall be sold as a going concern. पर जहाँ पे COC has not identified the assets and liabilities, there the liquidator shall identify and group the assets and liabilities to be sold as a going concern in consultation with the consultation committee. The liquidator may sell the assets of CD under E or F. Under E, E is the entire company as a going concern, exclusively, only at the first auction. Can anyone explain to me why this has been given? Only, exclusively, what is the meaning here?
You're talking about this 4?
Yes, the sale of a company as a going concern. Clause E of regulation 32 of the liquidation regulations talk about the sale.
Madam, could you take us to the slide?
Maximize the value, ma'am.
Yeah, maximization.
No. Maximize तो पूरा कोड ही कर रहा है.
अच्छा मैडम, आप जरा पीछे का उसमें स्लाइड में लेके जाइए जहां से आप रेफरेंस दे रहे हैं. Ika, yes.
The corporate debtor as a going concern. The liquidator may sell the corporate debtor as a going concern. The entire company as a going concern, not at the business as a going concern.
To get a competitive price.
Ma'am,
That could
only
be one of the
assets is-
reasons.
I think all this workforce will be re-employed when this company is being sold as a going concern. The sanctity and will be maintained like, as it was before liquidation.
Very well. So we understand the intent behind this clause. Exclusively only at first auction. तो first auction में आपको सिर्फ going concern वाला sale का try करना है, right? Will that mean कि अगर first auction में आपका नहीं बिका, thereafter आप company as a going concern नहीं sell कर सकते? Exclusively only at the first auction का मतलब क्या है? चलो मैं बता देती हूँ because we are running short of time. इसका मतलब है कि first auction में आपको सिर्फ clause E ही auction करना है. It does not mean कि second auction के time आप clause E नहीं कर सकते. Clause E is open for you for n number of times you carry out the auction. You can sell out of any of these options में से आप auction कर सकते हैं. Right? It does not stop you to sell the company as a going concern in the further subsequent auctions. Let us go through this judgment quickly. From the conjoint reading of the provisions of Regulation 32A4 and Regulation 32E, it can be inferred that the CD can be sold as a going concern only in the first auction. However, as regards to the word exclusively mentioned in Regulation 32A4, we are of the view that whereas the liquidator may sell the assets of the CD under clause E exclusively only at the first auction, we find no such bar in selling the assets of the CD in subsequent auctions also, where the liquidator has all other options of sale as stipulated under Regulation 32A available, including the selling of CD as a going concern. As seen from the record, in the instant case, sale of assets through more than one auction has already taken place. Therefore, in our considered view, the liquidator has the entire basket of options available for the sale of assets as stipulated under Regulation 32 of the liquidation regulations, and we find no legal disability for the liquidator in exercising any of the methods of sale under that regulation, including the sale of the entire company as a going concern. Right? So this exclusively only was only for the first auction and not for other auctions.
Acha, madam, just there is one question here. Suppose I have received a corporate debtor which was ill, which was sick prior to coming to CIRP. Say like, the company was admitted in 2020, whereas like, all the operations were closed in 2018 itself. And there is no further scope of revival. Then where is the concept of selling the company as a going concern? Because this is a gone company.
Let me tell you. There might be
some hidden, what you call permissions, sanctions, or approvals.
Let me tell you, I was coming to that point only. A company as a whole and a business, they are two different things to be understood by the liquidator also. आप क्या सेल करने जा रहे हैं, आपको क्या इंटरेस्ट दिख रहा है मार्केट में. जब when you sell the entire company as a going concern, it does not mean going concern under having the meaning under accounting standards. It does not mean going concern having the meaning under the Income Tax Act. It has its own specific meaning under IBC. How and why a company जिसका 5 साल से बिजनेस बंद है वो आज गोइंग कंसर्न में कैसे बिक सकती है? You have a really genuine question. But think from a perspective of a buyer who just needs a company जो कभी listed थी, जो कभी licenses थे उसके पास, जो कभी registered थी रेरा में, for example, जिसके पास कभी environment की clearances थी, जिसके पास कभी एम्प्लॉइज थे, जिसके पास कभी कोई ऐसे एसोसिएशंस थे, नेटवर्किंग थी जो कि उस नेम के साथ एसोसिएटेड थे. Those things are still available in the name of that company, and that company, if at all is taken by a buyer, he can start the business afresh by infusing more resources, including funds and people. Right? So this going concern is not that going concern as per accounting standards or as per Income Tax Act. This
Yes,
is the-
understood now. Yes, yes. This was the main confusion. We were just trying to, make it distinction between that in some other standard or in some other statute, if the going concern definition is something
Right,
different
right. वो
altogether.
definition इस पे suit नहीं करता है. चलिए. The mode of sale. Now we have seen the manner of sale. अब हम देख रहे हैं mode of sale. Mode कैसे हो सकता है? It can be auction, it can be e-auction, it can be private sale, it can be NRRA. So let us see all of them one by one. The liquidator shall ordinarily sell the assets through an auction in the manner specified in Schedule 1. अब बहुत clearly Schedule 1 में e-auction mandatory कर दिया गया है, and कुछ time में आपके जो e-auction service providers हैं, they will also be fixed and specified that they have to be registered with IBC or any authority which may be prescribed for them. So आपको उन्हीं के साथ ही करना है e-auction, उन्हीं service providers के साथ ही आप कर सकते हैं. The liquidator may sell the assets of CD by means of private sale if the asset is perishable, asset is likely to deteriorate, value is likely to deteriorate. You are getting a higher price than the failed auction, prior permission of AA has already been obtained, etc., etc. Provided that the liquidator shall not sell the assets without prior permission of AA by way of a private sale to a related party, his related party, or a professional appointed by them. Except these people, बाकी कुछ भी करके आप AA से authority लेके और justify करके you can sell it through private sale, which might be bringing you a better value than the auction. Liquidator shall not proceed with the sale of an asset if he has reason to believe that there is any collusion between the buyers or the CD's related parties or the buyers or the creditors and the buyer, and shall submit a report to the AA in this regard, seeking appropriate orders against the colluding parties. Asset memorandum.
Madam, in mode of sale, the corporate selling of corporate company as a going concern. Suppose a company operates in a food industry, where all the food items are perishable in nature. Can I sell that company in a perishable kind of condition, or I have to sell that company as a going concern?
You can go for a private sale, na? Why not? This is available for perishable assets. You can prove that you will get a better value if you directly go for a private sale and you have got a buyer there.
No, I mean to say that I'm going to sell the asset to the entire company as a going concern.
Even so that is the manner. This is the mode. Mode means आप कैसे बेचने वाले हो? E-auction से बेच रहे हो या actual auction कर रहे हो या private sale कर रहे हो, buyer को office में बुला के उससे बात कर रहे हो. So there are modes of selling.
Okay.
And that is the manner कि assets को piecemeal में बेचना है या क्या offer कर रहे हो बेचने के लिए, going concern कर रहे हो पूरा का पूरा या slum sale कर रहे हो, क्या कर रहे हो. And asset memorandum, you have to prepare this within 30 days from the liquidation commencement date based on the information memorandum prepared under section 29. For cases covered under subregulation 2 of 35, 35(2) का क्या है, where you have to get a fresh valuation done. In that case, you get 75 days for making this asset memorandum because the realizable values will change. Why? See the contents of the details of the assets which you have to put in the asset memorandum. That is the value of the asset valued in accordance with 35. Value of the assets or business under B to F of 32 valued in accordance with 35 intended to be sold under those clauses. Acha, regulation 35, here we are talking about regulation 35 of liquidation regulations, but otherwise also the valuation which originally was carried out in the CIRP, that is also regulation 35 only, I think so. Intended
Madam, can we make this asset memorandum in conjunct with information memorandum made at the time of CIRP?
I can't do that right now, you know. My presentation will not get over by 5 o'clock. I have to attend.
Okay, you please continue.
And I have not prepared a distinction between them. I'll talk to you separately on that and we can do a training session just separately. Okay. Intended manner of sale, आपको शुरू में 30 days के अंदर you have to have an intended manner of sale under regulation 32. The intended mode of sale, that is under regulation 33, we have just seen. Expected amount of realization from sale and any other information that may be relevant for the sale of the asset from the buyer's perspective. Regulation 34 is continuing. The asset memorandum shall provide the following details in respect of each of the assets other than those referred in subregulation 2. Value of asset, acha. Value of the asset, intended manner, expected amount of realization, and any other information. Liquidator shall file the asset memorandum along with preliminary report to the adjudicating authority. Liquidator shall share the asset memorandum with the board and members of consultation committee having voting rights after receiving an undertaking from each member that they shall maintain confidentiality and they shall not use the information to cause an undue gain or undue loss to itself or any other person. Now, this is the valuation we have talked much about. I'm just skipping this because under regulation 34 of CIRP, no, 35 of CIRP regulations में पहले से हुआ है, and you are you think that you have an opinion that a fresh valuation is required, then you will go under 35(2) of liquidation regulations. Asset sale report is prepared in respect of the assets which are sold all after the sale is complete. And this is enclosed with the progress report containing the realized value, cost of realization, manner and mode. Value realized is less than the value in the asset memorandum, then the reasons for the same, the person to whom the sale is made, and any other details of the sale. Now, a quick question to those who are awake. Tell me, when is a sale complete? When this sale report is to be given? This is to be given when a sale is complete. So एक मेरा auction हुआ जनवरी में, तो क्या मैं मार्च की रिपोर्ट में उसका सेल रिपोर्ट जाएगी? Every quarter I have to give the progress reports.
Sale report has to be complete in all respect.
No, my question is different.
Sale
के बाद progress report के साथ एक enclosure जाता है, that is called asset sale report. When you sell the asset by way of auction, when will you file that? When your auction is complete, is the sale complete? Will you file a report after the auction, the successful auction?
No, like, when, see, the process would be like, in such a way, like, I have gone for a e-auction, followed by deposit of money, and then highest bidder will be like, given the chance to acquire the asset. Then I will issue the agreement based on the agreement.
Yes,
I will
absolutely. So when the sale is complete, when the proper definitive agreements are entered into and the entire sale consideration is paid by the highest bidder. Highest bidder and identification or declaration of the highest bidder does not make the sale complete, right? So that's what I was trying to highlight. Assignment of not readily realizable assets. We have been doing that for the last 3 years, I think for the last 2.5 years, since when this clause has come into picture. हम तब से यही कर रहे हैं, and we have sold most of our assets under NRRA category only. A liquidator may assign or transfer a not readily realizable asset through a transparent process in consultation with the SEC in accordance with regulation 31A for a consideration to any person who is eligible to submit a resolution plan for insolvency resolution. For the purposes of this regulation, not readily realizable asset means any asset included in the liquidation estate which could not be sold through available options and includes contingent or disputed assets and assets underlying proceedings for PUFE also. So here is a lot of scope for all our liquidators who don't know, who are not able to decide how to deal with the pending PUFE applications. So here is your chance to sell them as NRRA.
Madam, suppose nobody comes forward to take up all this.
वैसे भी fail auction आप बैठे हैं.
Madam, regulation 38 है ना, like where you have to give
38 है ना. Let's go to that. The liquidator may, with the permission of AA, distribute amongst the stakeholders an asset that could not be sold either way, assigned or transferred due to its peculiar nature or other special circumstances. The application seeking permission under subregulation 1 shall identify the asset, provide the value, efforts made to sell the asset, and provide reasons for such distribution. Thereafter, the recovery of money is due. Liquidator shall endeavor to recover and realize all the assets and dues in a time-bound manner, maximization of value for the stakeholders. ये हमारा जनगण मन है, हम हर थोड़ी देर बाद ये आता है रेगुलेशंस में भी सब जगह।
मैडम ये तो बोलता है आप फाइनेंशियल क्रेडिटर को असाइन कर दो, सपोज आपका
बिल्कुल
37
करना चाहिए, बिल्कुल करना चाहिए। यू हैव गॉट दैट ऑप्शन, यू नो, लिक्विडेटर मे विद द परमिशन ऑफ AA।
बट
यहाँ
वो
पे
बोलते
नहीं लिखा है, यहाँ पे
हाँ,
नहीं लिखा है कि यू हैव टू गो बैक टू द SCC टू आस्क देम। You
because
can
they
do
are
that.
they are the one like the prospective assignee.
Yes, and they are the one who will not want to have those assets.
Yes. Then in that case, what happens to all this?
तो आप उनसे पूछने नहीं जा रहे ना, you don't need to take their permission. You don't need to even consult with them. You don't need their recommendation. See, liquidator may, with the permission of AA, if you are able to justify your the reason for that.
नहीं तो क्या करना चाहिए मैडम? सपोज मैं बेच भी नहीं पाया, इधर मैं इसको असाइन भी नहीं कर पा रहा
आप
हूँ।
AA के पास जाइए, एप्लीकेशन बनाइए, उसके अंदर आप प्रॉपर्ली रीजंस लिखिए, राइट दैट यू हैड मेड एफर्ट्स टू सेल द एसेट एंड यू कुड नॉट फाइंड द बायर्स, व्हाट एफर्ट्स यू हैव मेड जेन्युइनली, वो सारे लिखने पड़ेंगे। एंड इफ AA इज सैटिस्फाइड दे विल गिव यू परमिशन। व्हाई नॉट? हम लेके थोड़ा ना हमेशा के लिए लिक्विडेशन चलता रहेगा।
और नहीं, अगर टाइम ऑफ फाइलिंग और डिसोल्यूशन हम उसमें प्ली मांग सकते हैं क्या, लाइक जस्ट टू फॉरगो?
आप डिसोल्यूशन नहीं फाइल कर सकते अनलेस ऑल द एसेट्स आर सोल्ड। एट द टाइम ऑफ डिसोल्यूशन नहीं कर सकते, उससे पहले ही करना है आपको सारे एसेट्स का डिस्ट्रीब्यूशन। Now proceeds of liquidation and distribution of proceeds. Now this is the name of the chapter. All money is to be paid into a bank account. The liquidator shall open a bank account in the name of CD followed by words in liquidation in a scheduled bank for the receipt of all money is due. Liquidator shall deposit in the bank account opened under subregulation 1 for all monies including checks and DDs received by him as a liquidator, and the realizations of each day shall be deposited into the bank account without any deduction. The liquidator may maintain a cash of 1 lakh rupees or such higher amount, and all payments from that account above 5,000 shall be made by checks drawn or online banking transactions. Distribution. Now there is a regulation stating distribution. Now this was the topic of my discussion today. Subject to the provisions of section 53, the liquidator shall not commence distribution before the list of stakeholders and asset memorandum have been filed with the AA. The liquidator shall distribute the proceeds from realization within 90 days from the receipt of amount. CRP costs, if any, and liquidation costs shall be deducted before such distribution is made. Not at the time of realization, but at the time of distribution, you have to deduct the liquidation costs. A stakeholder shall forthwith return any monies received by him in distribution which he was not entitled to at the time of distribution or subsequently became not entitled to. तो ये 43 अभी कुछ टाइम से काफी यूज हो रहा है, wherein the proceeds of the liquidator has been directed to take back the proceeds from the stakeholders which he had already distributed and distribute the money to the employees whose PF dues etc. were due. So this clause, this regulation has come into picture these days. Completion of liquidation. I think this is going to be taken up by another speaker, but I'll quickly tell you important points. The liquidator shall liquidate the CD within a period of 1 year from the liquidation commencement date, notwithstanding pendency of any application for avoidance transaction. अगर कोई application pending है, even then you can go for a dissolution ka application. If the liquidator fails to liquidate within 1 year, he shall make an application to continue the liquidation along with a report explaining why it has not been completed and specifying the additional time that he shall that is required for liquidation. Then what shall be the treatment of avoidance transaction? The liquidator shall, on the advice of the stakeholders consultation committee, provide in the application, which application? Dissolution application, along with the final report filed under regulation 45 for the manner in which proceedings in respect of avoidance transactions, if any, under chapter 3 or fraudulent or wrongful trading under chapter 6 of part 2 of the code will be pursued after the dissolution or closure of the liquidation process, and in the manner in which the proceeds, if any, from the proceedings shall be distributed. So one example of this is you can say that let one bank or one of the stakeholder take charge of this let them agree to this, because this has to be as per their advice only. Let them take a charge of this application, or you can assign the avoidance transactions. The assignee will take a charge, and the returns, whenever you will be recovering any money, a schedule can be made. Whatever money is recovered shall be distributed to the stakeholders in the proportion of their claims, in the whatever share they are having right now. And some money, if the liquidator is still involved in monitoring or supervising such application, then liquidator can also have his share of money out of the recovery of amounts from the avoidance transactions. But this does not stop you from filing a dissolution application. Accounting and taxation impact. When a sale takes place under liquidation, first of all, GST, all of us are now aware, because this is an old, in 2020, we got this new, a change in the GST law, where previous GST number shall not continue, and the RP or the liquidator has to take a fresh GST number. They have to apply in their own name, and they are the, I think where it is, and they are the authorized signatory, authorized representative of the company for that purpose. So this law, I know all of us are aware, but there are certain changes, and I could not take many of them under my presentation today, because very recently in the budget speech also, our finance minister has introduced some changes, and I was not very sure whether they have been incorporated in the Income Tax Act or not. So 170A, 179(6), I think. So some sections were proposed to be amended, and I have not taken up those sections under my presentation today, but I request you all to definitely go through the GST Income Tax Acts and not take shelter of section 14 only, because it is only that the new suits or proceedings or new coercive actions which cannot be taken, but whatever is there already, whichever claim has been finalized, frozen already, any liability which has been crystallized already prior to the start of CIRP or the liquidation, not liquidation, of course, the ICD date, whatever liabilities are crystallized prior to the ICD have to be taken care of by the RP also. So,
Madam, just to further elaboration, suppose that income tax department or GST department's dues were pertaining to a prior CRP period financial year, but the assessment was done during this moratorium. How to deal with the situation in that case, when it will be deemed to be crystallized?
It will be crystallized when the final order will be passed. So
But
they
final
cannot pass an order of demand or recovery during the moratorium period. So if the demand order and the completion of assessment has taken place prior to the ICD, then only they are able to file the claim in respect of that financial year, which was immediately preceding your year of CRP, right? So final order crystallization has to be prior to the ICD. That is the key to understand. The latest circular has clarified that the proceedings conducted under IBC also adjudicate the government dues pending under the CGST or under existing laws against the CD, and it would be covered under the term other proceedings under Section 84 of CGST Act. Therefore, in cases where a confirmed demand for recovery has been issued by the tax authorities, for which a summary has been issued in form so-and-so against the CD, and where the proceedings have been finalized against the CD under IBC, CD, which is under IBC, reducing the amount of statutory dues payable, then the jurisdictional commissioner shall issue an intimation in such and such form for reducing such demand. In simple terms, the tax officer should abide by the NCLT order in insolvency cases and recover only that much GST dues as have been finalized by the respective tribunal. As the proceedings conducted under IBC also adjudicate the government dues pending under CGST Act or under existing laws against the CD, and the same appear to be covered under the term other proceedings in Section 84 of CGST Act. So now the other laws are also getting amended in light of the existence of IBC and the hierarchy given under Section 53.
Madam, suppose like in one of the CIRP matter, suppose liquidator has been appointed as at a liquidation stage, he comes to the knowledge that, okay, that change in the GST portal has not taken place by the RP. Okay, now he has sold the share and he has sold the assets of the company. But at the time of filing and depositing of GST as received from the buyer is not getting through. Then how to deal with this kind of situation? Should I?
Liquidator is also required to take fresh GST registration, right, within 30 days of the LCD. So he has to deal with the entire GST process afresh.
Can I take recourse of existing GST number and deposit this tax collection, GST collection on sale of asset during liquidation period?
I don't think. A fresh GST registration has to be taken, and I don't think if previous input credits are available. But for that, I'm not very sure.
Okay.
Yeah. Capital gains on distribution of assets by the company under liquidation. So it has a catch. Let's see what section 46 has to say, notwithstanding anything contained in section 45. 45 talks about the capital gain on the transfer of assets. So notwithstanding anything contained in section 45, where the assets of a company are distributed to its shareholders on liquidation, such distribution shall not be regarded as a transfer by the company for the purpose of 45. So no capital gain shall arise on such transfer, right? But then subsection 2 says, where a shareholder on the liquidation of a company receives any money or other assets from the company, he shall be chargeable to income tax under the head capital gains in respect of money so received. So the CD will not be charged anything, but the receiver of the money or asset will be charged the capital gain tax in respect of the money so received or the market value of other assets on the date of distribution as reduced by the amount assessed as dividend, if at all some dividend was pending, within the meaning of subclause C of 22 of 2, and the sum so arrived at shall be deemed to be the full value of consideration for the purposes of section 48, and a tax shall be calculated on that. So this is the same what I have explained already, because we are running short of time, so I'm just not getting into details. Section 178 of the Income Tax Act is an important section. It was applicable to the IBC until this amendment came under under the subsection 6 of section 178 of Income Tax Act. It says that the provisions of this section shall have effect notwithstanding anything to the contrary contained in any other law for the time being in force, except the provisions of IBC. So ye bolta kya tha? This was regarding company in liquidation, wherein liquidator has to inform to the assessing officer about his appointment, where assessing officer shall make inquiry and investigation, and whatever calculations he shall make, he will send the notice, he will send the details of the tax receivable on the to the liquidator regarding the CD, etc. So this entire section is now not applicable under IBC. So what it means when there is a conflict between provisions of code and those of Income Tax Act, the code prevails over the act. This is a well-established principle now. 178(6) of Income Tax Act specifically states that, therefore, the principles of the code in terms of priority, etc., shall prevail in all kinds of liquidation. In Companies Act and Income Tax Act have given it a clear carve-out regarding the liquidation under IBC. Requirements of giving notice, etc., are not conflicting with the code. Therefore, these need to be complied with. So, I go back to this B section, subsection 1, subclause B. It talks about giving notice of appointment to the assessing officer. So there is no conflict between this section and IBC. So I think up to this point, one can follow this section, and thereafter you don't need to follow the section 178. Various rulings have from time and again, they have talked about the IBC provisions, which are having overriding effect over the other acts, especially the Income Tax Act. Now, going concern sale, I'm just not taking up right now because IPs have to ensure compliances at all times in relation to TDS, tax paying, return filing, etc. Sale of assets received on. I need to go to the rainbow judgment because
Madam,
Okay.
please share this PPT to all
Yes,
the
I will.
participants.
Yes, I will definitely share. So let us go through some points I have found out from recent judgments, and they are interesting. Relinquishment of security interest. When secured creditors have the option between relinquishing their right in favor of liquidation estate and realizing their security interest individually, once they choose to relinquish, the repayment will take place strictly as per section 53 of IBC, which does not recognize any distinction between classes of secured creditors. तो आपका first pari passu था, second था, वो सब आप equal हो जाएंगे, right? So this is causing a major trouble amongst the secured creditors, amongst themselves, because first charge, second charge सब बराबर हो जाते हैं. Second charge वाला becomes in an advantageous position and first charge वाला deteriorates in its position. This most of us must be aware of. Jet Aircraft Maintenance Engineer Welfare Association matter. Here the questions in front of the NCLAT were whether the workmen and employees are entitled to receive the payment of provident fund, gratuity and other retirement benefits in full, since they were not part of the liquidation estate under section 36(4)(b)(3). So here we have already discussed this, and one amongst you had correctly said the treatment of the funds and the entitlement of the workmen and employees. Can you just repeat that? Somebody who told me about the treatment, that was absolutely correct interpretation of the these judgments, the crux of these judgments. In view of this, whatever matter was there in the jet aircraft, we arrive at the following conclusion. The workmen and employees are entitled for payment of full amount of provident fund and gratuity till the date of commencement of CRP, which is to be paid by the SRA, consequent to approval of resolution plan in addition to 24 months workman dues, as the workman is entitled to under 53(1)(b) of the code. It is made clear that in addition to the part amount of provident fund and gratuity as proposed in the plan, SRA is obliged to make payment of balance unpaid amount of provident fund and gratuity to workmen and employees. And Supreme Court, while it tolerated 30th January only, in this case, along with the other matters combined, upheld the decision of NCLAT in Jet Airways on payment of provident fund and gratuity of workmen and employees till the date of commencement of insolvency. So by mandating the full payment of workmen dues, the Honorable NCLAT and SP ruling has the effect of creating a special category of creditors which is not provided for under the IBC. They are only taking advantage of, they are only taking interpretation of section 36(4)(b)(3). Is anyone remembering what was this?
This was regarding, like, you know, if that trust is being maintained, trust is maintaining, there was a bifurcation. If suppose this the entire fund is
are not forming part of the liquidation estate, and
Yes.
the section clearly carves them out. And provident fund, etc., are also all the employee welfare funds maintained by the company are not forming part of the liquidation estate. The position of law with regard to explicit exclusion of EPF dues from the liquidation estate has now been endorsed and concretized by the Apex Court in another matter, Sunil Kumar Jain versus Sundaresh Bhatt, by explicitly saying that section 36(4) of IBC has clearly given outright protection to the workmen's dues under Provident Fund, Gratuity Fund and Pension Fund, which are not to be treated as liquidation estate assets, and the liquidator shall have no claim over such dues. So they are not available for distribution to the other creditors. Section 17(b) of the EPF Act creates an obligation on the transferee to pay the contribution and other sums due from the employer whenever an establishment is transferred. Therefore, by operation of 17(b) of EPF Act, the successful resolution applicant is made liable to pay the provident fund which the CD owes to its employees. Under this regime, not only has the legislature extended the earlier law, but also fortified the rights of workmen with respect to EPF dues. This enables them to claim their EPF dues without being subjected to the waterfall mechanism. Such an interpretation aligns with the purpose and object of the EPF Act of protecting the rights of the employees, for it being a social welfare legislation. But somewhere IBC needs to be either amended or a specific guideline needs to come, because certain creditors are being given separate category altogether. Just like the telecommunication spectrum, these spectrum assets, these licenses, spectrum licenses they call it, these are a separate category of assets altogether. And in the matter of NCLAT versus Vijay Kumar v. Iyer, the license dues were equivalent to contractual dues in the form of operational debt. NCLAT held that the Department of Telecommunication was classified as an OC, but at the same time, since the spectrum guidelines prohibited any trading in spectrum licenses without payment of past dues, DOT must be paid all its past dues for the licenses to be transferred under IBC. Your sale of asset is restricted if you don't pay the fees, if you don't pay the past dues, and therefore NCLAT held that the past dues need to be paid, and without which you won't be able to proceed to sell the assets. And the bidder or the buyer won't get anything because the license is not saleable without payment of the past dues. So this is in fact not in the true spirit of the IBC. The NCLAT decision has the effect of providing protection to certain operational creditors in cases where a license to use an asset specifically includes a term that prevents the transfer of asset unless all outstanding dues are paid. The past dues are not paid. That has to be covered, that has to be dealt with in a particular manner as per section 53 or the other related applicable sections of IBC, not in the manner of the contractual obligation under that contract. This would mean that all unpaid dues would have to be settled before the asset could be transferred without taking into account the debts of the other operational or financial creditors. Under section 53, IBC expressly prioritizes the interest of financial creditors, but here this OC has been given priority to all of them. They say that defaulting licensees or telecommunication companies cannot be permitted to wriggle out of their liabilities by resorting to triggering of CRP by seeking initiation of CRP under section 10, not for the purposes of resolution, but fraudulently and with malicious intent of withholding the huge areas payable to government, obtaining moratorium to abort the government's move to suspend, revoke or terminate those licenses, and in the event of a plan being approved, subjecting the central government to be contended with the peanuts being offered as OC. An appeal against this decision is pending with Supreme Court, but last year also, I'm not remembering the matter, Supreme Court also gave its judgment in favor of the telecommunication companies only. So certain creditors need to be dealt with, clear-cut guidelines need to be given. And we cannot remain in the state of conflict like we are right now after the Rainbow judgment. All of you, I'm sure all of you are aware of this judgment and where we are because as a result of this. But let me tell you, there was some anomaly, there was some mistake in the proposed amendment to the IBC in the MCA discussion paper dated 18th January 23. This has already been taken care of, and the definition of security interest under the code would now mean that a right, title or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation. So this definition will be this definition is already there. It is intended to be restricted to transactions, like I emphasized earlier also, by way of a transaction, which means that the security interest should be created pursuant to an agreement or an intention on the part of asset holder while giving rights to the other party. Further, the transaction as defined under section 3, subsection 33 includes an agreement or arrangement in writing to transfer the assets, funds, goods or services from or to the CD. Thus, it is very clear that the concept of security interest was intended to cover a consensual transaction between parties and not any similar interest created through mere operation of a statute. Clear? So the proposed amendment says that all debts owed to central government and the state government, irrespective of whether they are secured creditors pursuant to a security interest created by a mere operation of statute, shall be treated equally with other unsecured creditors. It will be clarified that only where the security interest is created pursuant to a transaction of the central government or state government with the CD, the government in question will continue to be treated as secured creditor in the order of priority. Great. Separation of resolution plans and the distribution of proceeds. Now, CIRP will also have a proper pattern of distribution of proceeds. The code may be amended to statutorily provide an equitable scheme of distribution of proceeds received pursuant to a resolution plan through a separate waterfall mechanism under the CIRP. As per this scheme, the creditors will receive proceeds up to the CD's liquidation value of for their claims in the order of priority. Thereafter, any surplus over the liquidation value will be distributed between all the creditors in the ratio of their unsatisfied claims. Whether you like it or not, this amendment is going to come. Finally, any remaining amount or further surplus would be distributed to the shareholders and partners of the CD as the case may be. It is expected that this will make the distribution proceeds fairer and more equitable for the other stakeholders, but I think this is an injustice to the secured financial creditors who have given huge amount of money and their money has been consumed by the CD over a period of time, and the money value has now gone into losses, etc., and CD is not in a position to repay, and that money has actually been invested in the company that should be repaid. As compared to the other stakeholders, I think secured creditors definitely need to be given a priority and some special treatment, but this scheme would bring them to a liquidation value only. In the matter of Assam Company India Limited, NCLAT held, in view of the judgment passed by the Honorable Supreme Court in the case of Rainbow, the dues of appellant are government dues and they are secured creditors. So until and unless we get this amendment, such kind of judgments will keep coming. And what they say, while going through the case records, we note that substantial amounts have been realized by the liquidator during liquidation process, including huge amounts of refunds issued by the applicant, that is the income tax department. The code specifically provides for a situation where the proceeds under liquidation have been distributed in contravention of the provisions of this code in this regard, and they refer to the regulation 43, and they ask the liquidator, they direct the liquidator to redistribute the proceeds from the realization of liquidation process as per the provisions of section 53 of the code by treating the income tax department as a secured creditor within 3 weeks of the order, and also to direct the stakeholders who have received the money beyond their entitlement to return the money as per the provisions of regulation 43. In Vivek Raheja, yes. Now do we have more time? Actually wanted to discuss this.
Sure, ma'am, you can.
So here what happened in this matter, I have only taken some portion from the entire judgment of NCLAT, but I would request, if you are interested in understanding where and how the secured creditor is, stuck in this process, and where and how he should, like I was suggesting you, in case you get a chance in a capacity of an advisor to a secured financial creditor or a secured creditor, not the secured creditor, the secured financial creditor only, who is at the highest pedestal in the waterfall mechanism, you must suggest them to value their security, to value the realizable value of by not relinquishing their rights, etc. Because in this matter, when you go through this, you will realize that they are only getting the, irrespective of having the value of higher value of the security they had, they were only getting the proportion out of the admitted debt amount only. And that is how the language says. So they have to have the debt owed to a secured creditor is not the value of security. The value of security is not the debt. That is how NCLAT has written. Give me a moment. So the value of security as compared to the ratio in the admitted debts one must consider both of them before getting into the relinquishment or not to be relinquished decision making. So Vivek Raheja matter, I would request all of you to go through this matter once and go through the entire judgment. It is very interesting to read, and you will get to know many the different aspect of how a financial creditor should think. In the Anil Anchalia matter also it was decided, and in the Anil Anchalia matter is there. They say that dissenting financial creditor is entitled for distribution as per 53(1). The claim of dissenting financial creditor that he is entitled to receive the entire amount received from the property which was secured with the financial creditor was rejected, relying on the judgment of honorable. The decision of COC and adjudicating authority deciding to distribute the proceeds of the plan value as per the voting share. So here also the question was same as was in the Vivek Raheja matter, that the distribution of proceeds shall be in the proportion of admitted dues and the voting share of the secured creditor, and not as per the value of security that was held by the secured creditor. Om Prakash Agarwal matter, it talks about deduction made in accordance with 194(1)(a) of the IT Act and paid to the central government shall be treated as payment of tax on behalf of the person from whom income tax deduction was made. Let's go to the end. 1% TDS is recovered on priority to other creditors, which is partial capital gain tax, whereas 53(1)(e) of the code in Waterfall provides that the government dues should come in 5th in priority. Therefore, any tax deducted by the government has to be returned. The NCLAT also opined that the liquidator of a company in liquidation under the code is not required to file income tax return. There is no question of claiming refund of TDS deducted under section 194(1)(a) of the Income Tax Act. Further, NCLAT observed that under the provisions of IT Act related to refund, it is a cumbersome process to take refund from Income Tax Department, and hence the code and IBBI regulations, liquidation regulations are silent on the subject of filing of ITR, as the code provides for a time-bound period for completion and maximization of value of assets and ease of doing business. So NCLAT has also given its opinion on how cumbersome a process of taking refund from Income Tax Department is. So the conclusion was in favor of the appellant, the Om Prakash person, he is a liquidator. The NCLAT held that section 194(1)(a) being inconsistent with the provisions of 53(1)(e) of the code, and by virtue of section 238, the provision of section 53(1)(e) shall have overriding effect. Therefore, the order of NCLT was set aside as not sustainable. Income Tax Department was directed to refund the amount of TDS deposited by the appellant, and the appeal was allowed in favor of the appellant. I don't think we have more time. I'll share this presentation, and it is having some more interesting points hereafter. And it was nice talking to you, Rajkumarji, especially thanking you for making the discussion and the interaction live, because otherwise I don't see people, I don't find anybody there. Videos are not on, and it's rather difficult if nobody is there to communicate with and speaking on your own, reading your own presentation.
Madam, we are listening.
Okay, thank you. So just switch on your cameras for a moment so I should know out of 65, 71 people, how many of you are awake? All right. Thank you so much.
Thank you, ma'am. Thank you.
Thank you.
So much.
Thank you so much.
Thanks to the institute.
Thank
and
you. Thank you so much.
Thank you everyone
Thank
for
you,
listening.
ma'am. The session was very
Thank you,
interesting
ma'am.
and
Thank you.
wonderful.
Thank you a lot.
Thank you very much, and please do share your number also in the
I
chat
will.
box.
Okay, let me do that.
Thank you, ma'am. The session was very wonderful and interactive. Ma'am, please share the PPTs.
Yes, I will share. Definitely. Thank you, Anjali, for being there.